Hmm? When? No, no. We'll have it on 11th. Mr. Datta, yesterday, one of your matters motion you moved that day, na? Additional evidence. That order I, although did not interfere, but I took care of the problem which you faced because of the earlier order. And there was an order, judgment passed by Justice Sapre. I still remember. When there is a scope of an additional evidence, there is always a scope of a rebuttal evidence. So I gave you that opportunity. So I gave you the rebuttal evidence scope. So thereby your problem which was there because of the earlier order, now I think it would be taken care of.
May I please your lordship? Lordship, may please list item number list RSA 180 of 2015 on 9 on 2025.
What do you want?
I want you to list the matter
Why?
because it is pending since 2015.
Number one,
Yes, your lordship.
and rejection is because of clause number 1 of the notice.
Lordships, MST matter, Lordships, for order, there is interim order, IA is given for interim for payment of 50%, Lordships. That is be listed on 13, Lordship.
Not 13th, 16th. 16th.
Oh,
13th,
public.
there are a lot of.
May it be pleases you, Lordship. Your Lordship, one matter, Your Lordship, I want to, Your Lordship, yesterday we have filed it, Your Lordship, for transfer petition. And the next date is on 6/6/2025, Your Lordship, for cross-examination. So I'm representing as legal aid counsel here, Your Lordship. So I am praying Your Lordship, kindly list this matter tomorrow, Your Lordship.
Right.
Your Lordship, there
It
is
is
a
on 16/6.
6/6 for cross-examination.
Okay. Motion.
Motion matter. I'm deeply obliged.
May I please, Your Lordship? First, I pray for listing and make appeal for orders, Your Lordship. A matter pending since 2022, Your Lordship. So my, or before vacation any date.
18th.
I'm so obliged.
May I please, Your Lordship? Your Lordship, I beg to mention about the land matter, CRP for motion. Your Lordship, in the present case, the plain petition.
Motion
Yes, Your Lordship.
tomorrow.
Yes, Your Lordship. Obliged.
Top of the list, item 1, part heart.
In page 84 of the affidavit, they are supporting my case only, whatever is written in the petition.
Then madam,
Whatever, my lord, that
when you are vacating. No, no, there is no question further. This is a matter going on from 2015.
Possession of the DAG number 5 or not, my lord.
Huh?
Whether we are in possession of DAG number 5 or not, my
Okay,
lord.
then I ask them to demarcate and you vacate the possession if you are there. Okay.
Kindly first, after that, kindly first.
So they have filed an affidavit to that effect.
Yes.
So nothing you mean.
My lord, they have filed affidavit, my lord. They have said in 84.
Where is that affidavit?
Eighty, 81 page number.
23rd April.
Yeah, not 23rd, yes.
What does
Page-
it say?
Page
Well,
number 84, madam.
Page?
Page 84. Running page 84, internal page 4.
Pertinent to mention here that the above remarks, the deponent begs to state that from the manual Jamapandi available in the office of the Imam, observe that patta number 6 of the said village, that is the area of Dag number within the total area of demand, has been partitioned out through the above mentioned partition creating venues, so and so, so and so, so and so. And in the whole exercise, an area measuring 1 bigger 2 kata 50 has been retained in Dag number 5. It is maybe categorically stated that Dag number 49 has been partitioned out of Dag number 5. It is also to be mentioned that the total area of Dag number of previous patta number 6 have been partitioned out by creating a new Dag. As mentioned in here, because of this fact, the online digitalized system does not mention about Dag number which is the chart Dag in Iman.
So it says, my lord,
Those
originally,
searches being carried out in the Iman and to look into the original recording of the Iman, wherein the final order was completed. Yes.
originally in Dag number 5, there was 14 bigger 3 kata 17 letters.
Hmm.
Out of this Dag, my lord, Dag 49 has been created, and this in Dag 49 there is 3 bigger 2 kata 19 letters. So we are claiming this
3 bigas, 2 kata, 9 less.
9 letters. And then, my lord, in 1 bigger 2 kata 15 letters has been retained in Dag number 5. So that is the case of the petitioner.
And you are the owner of this.
Yes, but I have the patta is there, Jamabandi is there.
My lord, kindly the
So
case,
now what do you want? What do you want?
my lord, kindly, case number 85, my lord, there's the para number 4, my lord. They have also stated in their affidavit, my lord,
Understood? But,
but there is no.
but no,
consisting
no, no, no.
placement.
But the question is, where is your allotment?
Allotment is they have also,
No,
admitted
where
in
is
their
your
affidavit.
allotment in Dag number 44, 48, 46, 49 or Dag number 5? Where is your allotment? The answer is simple. The revenue records clearly show that they are the owners of Dag number 49 and Dag number 5.
My lord.
Okay.
Yes, my lord.
Now, do you have any allotment in Dag number 49 and Dag number 5? If you don't have, when are you vacating the possession? Matter ends there. There's nothing more than that. We don't want anything.
And page 47 of the writ petition, there is a report regarding joint verification also. The revenue-
Everything has been done,
the
nothing is
revenue
remaining.
authorities have verified, they said that it is in possession of this CRPF authorities.
Well, as per page number 47, my lord, where is the land measuring so and so Dag number are in possession of CRPF, my lord. So, my lord, on the basis of that, my lord, kindly give directed to keep the demarcation, my lord, then kindly fix a date, my lord, after demarcation, my lord, so that honorable court may pass any order, my lord, on next day after demarcation, my lord, where is our position, my lord, to clarify that, my lord.
And you are going to actively help in the,
Yes.
let them go and first demarcate.
Yes, my lord.
This is full stop. It therefore it transpires that the petitioners herein are the owners of 3 bigas 2 kata 9 lechas covered by Dag number 49 and 1 biga 2 kata 15 lechas of Dag number 5.
Patta number 31.
Full stop. Of patta number
31.
of patta number 31. Full stop. Ms. Again, the learned counsel who represents the CRPF
Yes, ma'am.
CRPF authority submits that a direction may be issued by this court for demarcation of the said Dag numbers to ascertain the exact area of the petitioner's land, and the authorities and the respondent
Respondent number 2, my lord.
respondent number
CRPF is respondent number 2, my lord.
and the respondent number 2 shall aid in carrying out the said demarcations. Full stop. She further submitted that after demarcation, if it is found that the respondent number 2 is in possession of the dags belonging to of the land belonging to the petitioner, then only this court may pass appropriate orders. Mr. Joy Hendick, the learned counsel, J. Hendick, the learned counsel, appearing on behalf of the respondent number 4 and 5, submits that if directions are issued, comma, the circle officer of Sunapur Circle Office shall do the needful. Full stop. Taking into account the above, this matter on 16th of July 2025. Full stop. 15th of July 2025. Full stop. In the meantime, this court directs the circle officer, Sunapur Revenue Circle, who is the respondent number 5, to carry out the demarcation, only to ascertain as to whether the respondent number 2 is in possession of the land covered by DAG number 5 and DAG number 49 or Patta number 31. Full stop. The respondent number 2 is further directed to aid in carrying out the said demarcation, comma. Upon such demarcation, a report be submitted before this court by way of an affidavit.
From the top of the list, my lord, because that the hearing date may not. Top of the list, my lord. It's a here.
It's the matter on so and so at the top.
I'm declaring.
Item 2,
My lord, before opening the argument, my lord, we have given an offer to the respondent, my lord, that something more than, my lord, what is otherwise due to him in terms of the sale deed, we are prepared to pay. So that I do not know what my learned friend would have to say.
Lordship, till today I have not informed to that effect.
To the extent of 1/4, perhaps, my lord, we'll have to concede. So in terms of the agreement, the 1/4 would be a very meager amount, but we are prepared to pay something more. I think my learned friend can have the instruction.
Lordship, so far my information is concerned, they are not willing. Because the respondent won't be respondent, he is residing at USA.
No, my lord, regarding respondent number 2, let us be very clear about one thing, my lord. We gave that NOC. In the plain, there is no averment. Saying that, my lord, they are disputing it. Secondly, my lord, the money was received by her. In cross-examination, the PW1 himself admits that. So, my lord, regarding the share of plaintiff number 2, plaintiff number 1 cannot claim it. And if your lordship will kindly see the Wakalatnama, in the suit, her name is different. In the lower appellate court, her name is different. She never came down to India, my lord. And that's why, my lord, our NOC was countersigned by the notary in the America. So to the extent of second share, he cannot claim. That has to be adjudicated. That the trial court has miserably failed to do that, my lord. So therefore, my learned friend can have the instruction. The other day, we indicated to him, my lord, if he agrees, then, my lord, we can.
You are the plaintiff number 1.
I am plaintiff number 1. So far, that plea they have taken before the learned trial court. And that was affirmed by the learned trial court. The trial court also report from a letter, got a letter from that USA that yes, I filed this too.
No.
There's a report
Then
that
how
was
can, my lord, the
considered- that
name
was
is
considered-
different?
That was considered by the learned trial court. There is judgment in the judgment isn't reflected. I am not on that, your lordship, today. So far that please can they have taken that.
So, my lord,
I have
in
to-
in the
I have to take any
cross-examination, the PW plaintiff number 1 himself admits that yes.
That a report. He may be
Who
asked
filed
to-
the appeal?
Lordship.
We filed the
Defendants.
defendant.
The defendant filed.
And the
Then,
present appeal.
then in that case, why in the appeal the name was different?
Yes,
Appeal was filed by them.
You only filed the appeal.
Yes.
no, wakalatnama. Wakalatnama of plaintiff number 2 in the suit and in the lower appellate, first appellate court, it is different. Kindly see below the original records. I don't think somebody will incorrectly write, say, put his signature in wakalatnama. Two different names, kindly see below. And she never came, Milord.
Report, we have taken the report. They
But
already-
in your suit dismissed,
Lordship,
the suit was decreed.
Lordship.
Their suit was decreed.
Decreed. So appeal thereupon, whether the defendant appeared or respondent appeared or not, hardly matters.
No.
It is the appellant's
My
case.
lord, it does not matter, but having appeared, is it expected of a litigant to put two different names in two different wakalatnama? Will it not raise some amount of inquiry, my lord? And that was raised, where was it decided? And kindly see, my lord, the lower appellate court, my lord, the manner in which the appeal was disposed of, I can give the dates. My lord, 22/10/24, I personally went there and argued the matter, and the matter was fixed on 14/11/24 for judgment. On that day, my lord, my learned friend was not there, his junior was there. Then the opportunity was given that either you give a written argument or I am not going to do anything, the matter will be fixed for judgment. Then, my lord, when they appeared, when they argued, we never knew. And my lord, we never got an opportunity to furnish any rejoinder argument also. And one fine morning, my lord, we find the judgment. Let my learned friend explain that, my lord. On the day I argued, he was not there.
That's already the concept of rejoinder argument may be there in the high court, not there in the trial courts.
Well, at times it may arise.
Now the question is,
And my lord, if your lordship would kindly have the record as far as the cross of the PW1, my lord, he says it is true that share of land for plaintiff number 2 was deposited in her account by account paid check. She has not returned the said money to the defendant number 1. It is in cross, my lord, it is the version of the plaintiff number 1. In view of the order of acquittal, my lord, regarding the share of the plaintiff number 1, that we are not disputing. But where is the question of, my lord, without any partition, without anything, where is the occasion to, set aside the sale deed as a whole?
no, that too I am going to make it
Lordship.
correct now. That's the
The law
only
is very
question.
clear, Lordship. Law is very clear. So far, the decision of the Honorable Apex Court is concerned, which has been considered by the Honorable Court.
Now, this question is there.
Lordship.
The defendant number 2 and 3 were legally competent to transfer their share.
There,
Lordship. That
So
is,
the sale deed may be bad for other period, but this sale which has been made by defendant number 2 and 3 is good.
Good.
So you cannot set aside the
Lordship.
entire sale.
Lordship.
So that is why the question has been raised.
Lordship. So far, the Lordship, that citation has already been referred in another case by the Your Lordship. Air 2024 SC 4193.
Malava,
Lordship.
what is the name?
Hey,
Malava,
Gulam Lalsan, Lordship.
Sheikh Gulam.
Lordship Gulam Lalsan. He was a purchaser. So the Honorable Apex Court in para 21, it has been clearly stated.
So it will be good insofar as the entire sale deed cannot be said.
Yes, that salary cannot go.
This transfer duly happened.
Lordship. So make clear by the Honorable Apex Court. Lordship, may I read it out?
What is the prayer in the suit you have sought for?
that sale deed is void, illegal, inoperative, not binding on the plaintiffs.
Mr. Counsel, you have not asked for partition
Lordship, at that time.
now.
Lordship. Now I am coming to that. Because that question raised before the Apex Court. This type of same question has been raised in the Lalsan case also. It has been held by the Honorable Apex Court. May I read it out, Your Lordship? Just I am reading out the relevant portion of the citation.
Apex Court must have said the partition is on the volition of a party whenever they feel like they can ask.
Lordship. the said shall lead, if at all, in accordance with section 44 of the Transfer Property Act 1882, may be a valid document to the extent of the share of Brij Mohan in the property, and the defendant appellant S.K. Gulam Lalsan is free to take remedies to claim appropriate relief either by a suit of partition or by a suit of compensation and damages against Brij Mohan. That is the ratio laid down by the Honorable
No. So how do you get the relief for the recovery of possession?
Lordship. That can be, relief can be molded by the Honorable Apex Court. Now I am coming to section 44, whether section 44 will be applicable because proviso is there. Because in the sale deed, it has been clearly mentioned that there is RCC building. If there is an RCC building, if it is an ancestral property, under section 44 proviso, where the transfer of a share of a dwelling house belonging to an undivided family is not a member of family, nothing in this section shall be deemed to entitle him to joint possession or other common or part enjoyment of the house. So make it very clear. In the sale deed, it has been clearly mentioned that there is a dwelling house.
But is it your claim that you are staying out there in the
Lordship.
dwelling house? Is it your claim that you are staying in the dwelling house?
No, I am not on
Because the
that.
dwelling house concept comes
Lordship.
in,
Yes, yes,
you have
Yes.
to also see that section 44
I'm-
was made at a time
Lordship.
when we did not have
Lordship.
the amendment to section
Because at that
6.
time, what happened, your lordship, the situation is different.
Huh?
I was being arrested. I was convicted by a trial court. I was in jail.
No,
And
whatever may be,
But,
but the
on the
question
date
is,
suit was
no, you
filed,
may
but
have
not
a
in
joint
date.
possession.
lordship,
He may ask for partition.
Lord.
These are various other things which may happen later on. But the question of granting a decree for ejectment does not arise.
so far the other two parties concerned. I'm not.
But
on
how
that.
do you take care of a situation?
Lord.
That
So
without,
that
if
means
you are,
either by the plaintiff side or by the purchasers, the appealant before lordship, both of them can file a suit for partition. So for the two shares is concerned, that is a valid transfer. I am not on that. Before your lordship, I submitted before this. That is a, so for the two shares is concerned, it's a valid transfer. So for the sale deed is in respect of concern. But so for the other two shares, that is suit filed by the two persons, that is the legal heirs of the our man, respond number 1 and 2. Now their claim is that they paid the amount. All right. Paid the amount. Who received it? Whether there is any
no,
parliamentary.
paying the amount also would not make a sense because the transfer has to be by in accordance with the transfer of.
Party. That is the law. So
So the sale deed, my question therefore for me to get rid of this matter as of now is only to decide this substantial question of law.
law.
That the sale deed would be good insofar as even, however, you will have right title and interest in respect to the joint possession, the land.
Another aspect for judgment is there, lordship 2009. Because it has been 2009, your lordship, the judgment of Honorable Apex Court 1954 has been relied. There's two decisions has been relied, one of 1966, one SCR 628, and another judgment relied 1954 SCR 177. In paragraph 15, now 5466 judgment. Now it is a settled law that the purchaser of a co-personal undivided interest in the joint family property is not entitled to possession of what he had purchased. His only right to sue for partition of the property and ask for allotment to him of that which on partition might be found to fall to the share of the co-personal whose share he had purchased. So after partition being made, that is when the court will decide it is your share, then he will come into possession. That is the law. Another decision 1954 That was there. All the, that is within the Bhendi, purchase at the execution sale was the undivided interest of the corporation in
But
the joint
Mr.
property.
we are all understood.
Lordship,
He is in possession.
Lordship,
He is in possession. How do you, without a partition, seek for an ejection?
Lordship, partition is required. I am admitting it. Partition is required. Whether that will be filed by the plaintiffs or the plaintiff side or by the the defendant side, partition is necessary. I am on that. I am not disputing it because partition is to be made. But before partition, what will be the consequence?
What is the nature of construction being made?
RCC,
They made it.
yes. They have not made it. Initially, there was a construction of 1400 square feet. Out of that, our mother has constructed, our mother, father, parents constructed 750 square feet. And it is existing now, they are letting it out.
So there's no new construction. being-
New construction has not been made.
But tell me, what do you say about the proviso to section 34? Asking not, you know that they are in possession
Yes,
without asking for partition.
lordship. But that, so even if your lordship, relief can be molded. Because relief can be molded. But for that, the plaintiff cannot be denied his right. Relief can be molded.
So the relief which you are seeking is merely a suit for declaration. It's only a
That's what to
declaration.
declare that the sale deed is null and void. When the sale deed in respect of 2 shares will be valid, then the question of partition will come. Definitely that will come. Definitely that will come. Because after declaration, that his sale deed is valid up to his valid up to 2 shares. Then the relief of partition will definitely come.
So how do you have a partition of 2 shares? Their rights without a partition?
Lordship.
As of now,
No.
defendant number 2 and 3 sale deed is good.
Good.
Now, how do I say that which part is good?
That will be made by the trial court again, make it partition.
But the partition prayer is not there.
No, here is not there. But the
How,
part-
how did it happen?
That is
So-
separately, partition should be come.
So your right will be there
Lordship.
over the share to the extent of
To the extent of their share,
which how much? 3 katha 8 lechas.
lordship, out of the half,
There were 4 persons.
4 persons. As on date. Lordship, what happened in it, at the time of execution of this sale deed, father was alive. That fact also considered, I am not on that as on date. Because when this sale deed was executed, it is
But it
admitted by them.
makes no sense taking into account the moment the father died, everybody
lordship.
got their shares.
Yes.
So by the time when you filed the suit, the father was dead.
Lordship. But at the time of execution of sale deed, father was alive.
No, but
Finally,
the
you
time
can-
when you filed the suit, the father had
Father is
died.
dead.
So that transfer which has happened, it
Lordship,
cannot be
lordship.
gone into now. So it is around 68. It will be 34. So 1 katha 14 lechas each.
Each. In it. Sorry, lordship. 3 katha 8 lessons, lordship.
Total is 3 katha 8 lechas.
3 katha 8 lessons. 60 plus 8. 68 lessons divided by 4, your lordship.
No, that is for 1. We are concerned with 2.
We are concerned with 2.
2. So that
So
will be
each share will be-
34. 34 lechas,
34.
which makes it 1 katha 14 lechas,
Lordship.
isn't it?
Lordship. It will better for both of them. your
So
lordship.
their sale deed, so far as 1 katha 14 lechas has to be held to be valid.
Valid.
And what is this, with the area of admeasuring 705 square feet? In your, in your. plea?
Originally, it was when the cell deed was executed, the construction was only 705 square feet. Now we have done, Millard, pursuant to that, now it is much more. After purchase, we have made the further construction. It's not correct that no construction has been done by us. At the time of purchase, it was 705 square.
How much you have made?
That
No, it must be-
exactly,
No, there is,
No, it must be stated in your.
no, no,
plea.
there is no, there is nothing.
So
no,
these
it's not
things-
there,
no,
but
no.
we paid.
No, it is not stated.
We can't take into account anything like second
No,
appeal.
Millard, no, my learned friend has made a statement that after purchase, we have not made any construction.
But if you don't say that, he is making an
that is the
averment, you
question.
have to
There's
say,
no
deny
mistake.
that.
But Millard, what will happen to proviso to section 34 of the specific relief act, Millard? That is an answer. The answer which my learned friend is given is now he will file this suit. But the spirit of proviso to section 34 is something which you have not omitted to do so, then you have missed the bus.
The answer is Supreme Court AIR, Supreme Court judgment wherein you have, did you raise that issue?
No.
In your plea?
No,
If you don't raise, you cannot.
that question not.
No,
Supreme
Millard.
Court is clear
Now,
on
now I am on a very simple point, Millard. To the extent of 1/4 share in the property, perhaps, Millard, we cannot say no. But to the extent of the share of the daughter, Millard, why the trial court did not raise the issue of framed an issue, Millard, and decide it?
Which one?
Is to the extent of the share of the sister,
Plenty number
now my
two.
learned friend's entire case is based on half. On what basis he is saying half? Who he represented whom?
The
He
plaintiff-
represented basically the plaintiff. No, that we are disputing. That we are disputed in our written statement. If trial court does not frame an issue, my lord, what do I do? We can come only in appeal. I'll kindly see some of the pleadings and kindly see their evidence part. Whether as far as the share of the sister is concerned, an issue ought to have been framed. Whether she is before the court to prosecute her case.
Are
That
you-
is not even done.
But Mr. Chaudhary, are you denying the title of your mother?
No, we are not disputing her share. We
You are-
say,
No, you are not denying the title of your mother.
no,
And you don't deny the fact that it evolved upon the plaintiff number 1, 2, 3, and 4.
yes.
And the defendant
Yes.
number 2 and 3.
Our case is, my lord, our case is, this cell deed was between defendant number 1 and 3 of them. Because at that point of time, he was a convicted person, he was in jail, therefore in terms of section 25, Redwood 27 of the Succession Act, my lord, he had no right to inherit. That is why the cell deed was executed with the 3. 1 did not sign it, he gave an NOC, but that's a different aspect. But she received the consideration money. And in evidence, it has come out that she received the money. So where is the question of half?
Without a sale deed.
My lord?
Without a sale deed.
No, my lord, she executed and no objection, which was notarized in America, which was exhibited as Exhibit C. It's a
No,
different matter, my lord.
No, no,
What is the-
understood. But Mr. Chaudhary, how there is a transfer possible without there being a conveyance?
No, my lord, has she come to claim that this is my share of the property? Somebody else has come, the plaintiff number, he is putting her signature. That's why I said, my lord, when will a person, will I write my name incorrectly, my lord, in 2 different documents? At least one thing one will never forget is his name. Kindly see the Walatnama in the 2 proceedings. Is it conceivable, my lord?
Did you file a petition before the trial?
This
Appellate
question
court?
was raised.
No, no. Did you file a petition before the first appellate court?
No, it was not. My lord, there are some
All these
lacuna in the
things,
trial
all
process.
these things, Mr. Chaudhary, would have been very fair in a writ petition. Not in a-
No, I know the
Second
distinction between a writ petition and a.
Problem in the
pursuit.
second appeal, there is a very difficult thing to touch all those things.
No,
now.
my lord, it's a related issue. The issue which your lordship has framed, even in that, my lord, this entire gamut can come in. That's why I'm saying, my lord. The section 34 aspect, then, my lord, whether he is entitled to half or 1/4, these are aspects which can definitely be gone into, my lord. And kindly come to page 99, my lord, the trial court itself has dealt with it, para 28.
Trial court judgment?
Yes, my lord. Paragraph 28, page 99. Para 27. Defendant appellant has a lawsuit got it. Another point that the learned trial court has been wrong in comparing the signature of the plaintiff number 2 on the Wakalatnama and the plain with the signature of the letter sent by plaintiff number 2 from USA. Section 73 of the Evidence Act empowers the court to compare signature, writing or seal with other admitted or proof. Though court is not competent and not an expert. The trial court compared the signature of plaintiff number 2 on Wakalatnama with the signature on the letter addressed to the court by the plaintiff number 2 from USA and found both signatures to be identical. This court is of the view the learned trial court has compared the admitted signature of plaintiff number 2 with that of the Wakalatnama as empowered by section 73 of the Evidence Act and not beyond law. Trial court has rightly held that said finding of the trial court has been unchallenged, and as such verification of signature of the plaintiff number 2 by a personal attendance is not necessary, and the trial court has rightly found this suit is maintainable. It is not that this issue was not before the court, my lord.
No, not on, you have challenged there at the time of filing of the plaint, not in the appeal. In the appeal, you did not raise that because what you are submitting out here, that the Wakalatnama which is appearing in the trial court and in the appellate court are both different. That is not what it is.
And page 53, my lord, trial court's order.
Yes.
Next point raised by the defendant for non-maintainability of this suit is this. The plaintiff number 2 had by way of NOC duly notarized in USA authorized defendant number 2 to execute the sale deed in favor of defendant number 1. The share of the plaintiff number 2 out of the sale proceed was deposited in her account and she has neither returned the same nor prayed for cancellation of the NOC. She has not even appeared in the court to support the case which is being prosecuted by plaintiff number 1 alone. So for the facts of authorizing defendant number 2 by of NOC depositing share of the plaintiff number 2 in her account, not returning the same by plaintiff number 2 are concerned, all these are matters relating to merit of the suit for which investigation of the relevant facts and evidence will be necessary. From the point of view, the suit is very much maintainable. Let me now come to the other aspect that the plaintiff number 2 has not appeared in court to support the case which is being prosecuted by the plaintiff number 1 alone. At the very outset, let me state that the suit was filed by both the plaintiffs. The plaintiff and the Wakalatnama bear signature of both plaintiffs. The verification and affidavit are signed only by the plaintiff number 1, and I do not find any illegality in this as because verification and affidavit as per order 6 rule 15 of the CPC may be done by one of the plaintiffs. The defendants have disputed the signature of the plaintiff number 2, but by order dated 1406 passed in this suit, the predecessor in office of mine had held the signature of plaintiff in the Wakalatnama is identical to the nature of the plaintiff number 2 in her letter dated so-and-so, which was sent to the court from USA. It was, my lord, examined from the point of view of whether the signature in the letter sent from USA and the one appearing in the Wakalatnama was same. But what about the other aspect, my lord? The names are differing.
But that is in the appeal.
That is in the appeal. At that stage, it did not arise. On that basis, the then predecessor in office of mine.
No, but tell me one thing, the NOC which was issued, is there any challenge to the NOC?
No. No.
What is it? Let us see the NOC.
No,
NOC is exhibited as exhibit.
Exhibit to what I GW হবে না? Right. Yes.
Lordship, Exhibit C.
Tell me another thing, Mr. Bhuya.
Lordship,
Whether the NOC which is being done before the notary, is it done before a notary?
Yes.
There's no challenge to this document?
doesn't exhibit it. But so far the evidence is concerned, Your Lordship. May I read it out?
No, wait.
Where did the evidence laid, DW1? They have exhibit. Exhibit C is the photocopy of NOC dated 12/5/2023, Joylakshmi Bora. It is their statement in the DW1.
No, maybe, but it has been compared with original mentioned. Yeah. Exhibit C. Done by the civil judge 3.
Hmm.
But all said and done. Whether they mention is no objection or whatever may be, I authorize my brother to act on my behalf for sale of the property. Wouldn't that be a power? Given under 33(1)(c) of the registration. If it is a power, then the sale insofar as he is
IPR is
concerned
concerned.
is good
If it is not a power, then
power. And if the sale is good insofar as this is concerned, that is good. And she may have received the money, may not have received the money, but the fact that there is a sale deed she has pursued, and the sale deed was given in the year 2003 and the suit was filed in the year 2005.
2005.
So this is within limitation.
Okay.
This is filed within limitation. Now because what does the plaintiff number 2 say in her evidence? She has not
He
given
has
any
not
evidence.
made any.
So plaintiff number 1 has filed a suit.
Plaintiff number 1 and 2 file this suit. Plaintiff
No,
number
no,
1
one,
deposed.
no, 2 is okay. But what is the status of the 2 insofar as plaintiff? Because they are independent titles.
Both of them independent title.
So what the 2 does, wouldn't there be a problem because of the fact that she has not come to give evidence?
So for the NOC part is concerned, so that is to be looked into. question of law.
Not, yeah. So the share of one person, that is the plaintiff number one, is good for you, but not 2 and 3 and 4, because 2 never come to give evidence, nothing has been done. So it will be the 1/4 share.
So that there's been lawsuit.
You may have
Sure.
a right, but only to
But
the
if the
extent of one.
attorney, power of attorney has been given or authorized by the brother number one, plaintiff number one, then the method be different.
Only see exhibit C,
Copy of that.
have a look. And see the
So that
registration.
point will be clear before your lordship, whether that NOC can be treated as a power of attorney or not.
No, this is appears to,
Appears to be lordship, even then.
though I'm
Lord,
not going to frame any substantial question of law on this and give you 1/4, that is a different thing.
Power of attorney executed before and authenticated by a notary public.
Therefore, if you see section 33(1)(c),
That's what we learned. The principal at the time aforesaid does not reside in India. A power of attorney executed before and authenticated by a notary public
or a council,
council
or a vice council,
or a vice.
or by any officer of the central government.
Yes, of the center.
And lordship, so the deed is to be registered. When I have empowered somebody else to transfer my share by a registered shall deed, sir, the deed is to be registered.
Not necessary, that is what it is, section 33. 33(1) says that it has to be registered.
Lordship,
32(2) says, 32(1)(a) said it has to be registered.
registered.
If it is a place where, just for example, where in the act, 32(1)(b) says that in a place where there is, where the registration act does not apply, then in that regard, it can be done before a magistrate. 33(1)(c) says that when a person does not reside in India,
Does not reside in India. In a power of attorney executed. You know,
now did you raise objection to exhibit C?
Question was put before him.
But you did not raise objection, put it under objection.
Go to his lordship.
If you have not raised an objection, otherwise you had a case. Because it has to be also
I have to go to the evidence of detail.
stamped in terms with section 31.
31.
It is not stamped. Without it being stamped, it cannot be put into execution. But you have not raised an objection to that.
I have to go to the evidence.
But that is only for plaintiff number 2. But plaintiff number 1 has a case.
Yes,
So what to do? Finish it off. Finish it off.
lordship, at least 1 week time may be given so that I can go to the evidence whether that question has been raised or not. Because I was not before the trial court. I was in appellate court. The issue is different. So that is why I have to go to the evidence, cross-examination part of that.
Because in terms of section 31 of the Stamped Act, when a document which is outside, which is not stamped,
Not stamped.
you have to file an application before the register, which will be the deputy commissioner. And you file that application, he will notify what is the amount in the stamp.
Lord.
And on the basis of that, it can be used. Now,
but it-
therefore, you then have to take note of the judgment of the Supreme Court, recent judgment of the Supreme Court in the arbitration matter, wherein it says what is the effect of an unstamped document. Because the question involved out there is if an arbitration clause does not require a stamp, but it is in an agreement which is not stamped,
Not stamped.
that can it be taken into consideration? Because I think Justice Joseph and Justice Ravi Kumar said that these are non-S, you can't take it. This could not have been admitted into evidence itself. I think more particularly the concurring opinion of Justice Siti Ravi Kumar.
Lordship.
Have a look at that.
Lordship, I will go.
Then see the sale deed in so far as C also
Lordship.
could not have been admitted into.
Lord.
I'm giving you the idea
Lordship.
to both of you.
Lordship, I'll go to it. Lordship.
To make a second appeal, which is otherwise user.
Also have that instruction which we have offered to him.
Yes, please take.
Definitely, I have the instructions of the.
No, if they want to purchase that,
Yes.
have a word with them.
Lordship.
And more particularly the plaintiff number one. Take into account that because of the fact that if he wants the money, it's okay, they have built the house, if you can settle it out. You want that, at the end of the day, it's the question of the money.
No.
You can't do anything because you have to again fight another long battle for partition.
But-
It is not an easy thing.
Not easy.
If you have used the word partition in the suit, it would have been
If the
different.
partition,
I could
question
have
of
passed
partition
that
will come,
order.
Lordship, that matter will be very easier for both the parties.
Because if you see the earlier matter, which I did it on last Tuesday, na? Tuesday, I passed an order where there was a thing that the prayer was if for the purpose of recovery of possession, it is necessary for partition, then kindly grant the partition. If that prayer was also here, I could have given it.
Definitely.
But without that, going for
The
ejectment means
concept
going for
was
a
that at that
partition.
time of probably that this, if this LD is valid, entire property is to be recovered. That was the concept of at the time of filing this suit. When the matter has come to this to this end, that this LD is valid, then it will be observed by the, to be observed by the honorable court. Then the question of partition will come, definitely partition will come.
But the Act of 1882 then also was there.
Lordship.
Okay. Hearing remains inconclusive. Mr. K. N. Chaudhary, the learned senior counsel, submits that an offer has been also made that the Mr. K. N. Chaudhary, the learned senior counsel, on instructions from his assisting counsel, submits that without prejudice to the rights of the appellant in the instant appeal, and the appellant is not adverse to providing an offer for purchase of the 1/4 share of the plaintiff, number one. Full stop. Mr. R.K. Bhuyan, the learned counsel, submits, appearing on behalf of the respondent number 1 and 2, submits that he obtain instructions in that regard. List this matter again on when? 24th.
Lordship, 24th of June.
Item 3, hearing under order 41,
Lord,
Rule 11 CPC.
Lord, could it be on 20, Milord? 25th of the Jan?
No 20.
22 is Friday,
24th, I'll not be there. sir.
27, the
No, no,
12, 20,
24th
26.
night, 24th night.
Mr. Chaudhary, do you think-
Before 24, Milord. I'll be out from 24th onwards. Milord. Any date before 24. Between any date between 16th and 20, Milord.
17th,
17.
17th?
Oh, Lordship.
Deeply. observed.
Item 3,
Deeply, your lordship. In this case,
Hmm.
my lord, this, on the last occasion, you lordship heard the matter, my lord, and thereafter, you lordship was pleased to call for the original date of my lord. But in the order, obviously, I have not seen that order, my lord. That order has been passed in the connected civil division, my lord.
Civil revision. person.
That case is coming on to 10th of this month, my lord, as per your lord's order, my lord.
In the civil revision.
Civil division, my
But I don't require the records for this matter.
lord. My lord. In that case, I.
Yeah, the question is first whether a case is made out for framing a substantial question of law.
My lord, that, but further, I'll take lordship. Okay,
You are the plaintiff.
I'll the plenty, my lord.
Your plaintiff case is that you sought for purchase.
Mal, that's it for my, so it was filed for like, this, mal, agreement, mal, for
Specific performance of the
performance contract,
contract
madam.
for sale of a plot described in the schedule below on payment of the balance of 95,000 to the defendant.
Well.
That's it.
okay, mal.
Now, what is the contract?
What about as per the, as against that, mal, to deep, plenty has already made a payment, mal,
Hmm.
and that has been received towards the selling of the land. That especially that was mentioned in the exhibit of 16, 17, 18, and 19, mal. That agreement that was not considered by the both the court, mal, by the trial court as well as by the appellate court, mal.
So the agreement was entered into in the May to 1998.
my lord.
You filed a suit in 2006.
Correct.
Why?
Uh,
How do you take care of the limitation? The last
Yes,
of
sir.
the payments have been made
Made that was paid
by
on
the
my lord.
Mayman, who was a part payment and defendant assured their demand. This assurance was given on 15/4/1999. Then there is not a single statement. What happened thereafter?
Many people have been actually first, the last occasion also I submitted before Lord, so Lord, the judgment passed by the appellate court that was not in the conformity with the mandatory provisions of law as laid down under order 41, rule 30 and 31, my lord.
Not necessary.
Well-
We'll take care of that. But what is your question on limitations?
Therefore, that's my lord.
How do you take care of that?
Well-
Your agreement was entered into in 1998.
My lord.
Your last of the cause of action have been stated to be in the year 1999. And thereupon in 2015, there is a case being filed, and therefore you filed a suit in the year 2016. 2005, a case has been made. There's not a single word.
In a plain, my lord.
Uh,
Plain, my lord, you will be fine it.
On the face of it, your suit
Well-
is barred by limitation. Whether the courts below have dismissed it on
No,
that ground,
No, my lord, on that ground, no, there's no any issue, my lord.
we take
There's
it,
no any issue, my lord.
we take it is a question of law. We can take it at any point of time. On this ground only we'll discuss it. Otherwise, you failed also to prove the agreement. It's an oral agreement.
It was an oral agreement, my lord.
Huh?
That connected revision petition, my lord, that they are already, the notice has already been issued by this honorable court, my lord.
And you are in possession of the other property also.
No, I am holding a property, my lord,
Okay, so
both
by
the
the,
house and the land, my lord.
so this I dismiss now and the other will dismiss on which the state we want.
My lord.
That they just take your instruction by the time that you need 6 months. 2005 and 2025, it's too much.
From since 1986, where he's holding the property in the previous month, possessing the land, like their house, my lord, where he is carrying on a big business for the last so many years, my lord. That's when they
That day, Supreme Court allowed an eviction after 64 years of being there. In the business. You are less. You are there only from 98. Chalo. Morning, one dismissal goes.
No, my lord, it should be changed 1986, but not 98, my lord. But that was an agreement, memorandum agreement was dated 10/8/1986, my lord. If it is holding the property, my lord. Not only the house and also the land.
Where are your substantial questions of law?
That I have formulated, my lord. That at page I will also find at page 10, my lord. When the judgment both by the trial court as well as the appellate court, they have not stayed, but in which part about the oral evidence, my lord. Not only this documentary evidence, regarding the oral evidence also, they have not discussed, my lord.
And why you are bringing Assam Temporarily Settled Area Tenancy Act? Huh? Yeah. Perverse, being not based on evidence and on record, both oral and documentary. Then totally failed to decide the issues framed in the court by discussing the evidence on record, both oral as well as documentary, by formulating the points for determination, which violates the mandate. Okay, 1 and 2.
1 and 2, my lord.
Others we dismissed.
No,
And the others we don't take it all.
Well.
1 and 2 we take it and then dismiss. Mr. N.C. Das, the learned civil counsel assisted by Ms. So and so. Please take
Yes.
your seat. Come. This is an appeal filed under Order 41, under Section 100 of the Code of Civil Procedure 1908 for challenging the judgment and decree dated 31/10/2019 passed in title appeal number 6/2017, bracket earlier numbered as title appeal number 10/2010 by the Court of the District Judge, Dibrugarh, whereby the appeal so filed by the appellant was dismissed. First, at the outset, it is relevant to take note of, it was dismissed, thereby affirming the judgment and decree dated 27/1/2010, passed by the learned Munsif number 1, Dibrugarh, in title suit number 39/07. First, at the outset, it is relevant to take note of that the instant appeal has been filed insofar as the dismissal of the suit. First, however, in respect to allowing the counterclaim a separate proceedings under Section 115 of the Code of Civil Procedure 1908 have been filed, and which is presently pending before this court. Next, the question which arises before this court as to whether the questions of law so proposed in the instant appeal can be formulated in terms with Section 100 bracket 3 of the code, 100 bracket 4 of the code, so that the instant appeal can be proceeded with. First up, Mr. N.C. Das, the learned senior counsel appearing on behalf of the appellant, have drawn the attention of this court, submitted that he proposes two questions of law which can be framed as substantial questions of law in terms with Section 100 bracket 4 of the code. The said questions so proposed are 1 and 2 to page 10, not 1 and 2 do they do. Next, the question which arises before this court as to whether these questions which have been proposed, questions of law so proposed by the learned senior counsel appearing on behalf of the appellant, can at all be formulated, first of taking into account taking into account, it is noteworthy to take note of that the instant appeal is being taken up at the stage of Order 41, Rule 11. Next, for the purpose of deciding the aspect as to whether the two questions of law so proposed can be formulated as substantial questions of law, this court finds it relevant to take note of the facts which led to the filing of the instant appeal. First, for the sake of convenience herein, the parties are referred to in the same status as they were before the learned trial court. The plaintiff, the appellant herein as plaintiff, had filed a suit being title suit number 9/2006, seeking specific performance of an oral agreement for sale entered into in the month of May 1998 between the plaintiff and the defendant number 1 for sale of a plot of land measuring 30 feet into 52 feet is equals to 1560 square feet, equivalent to 10.8 lectures, under DAG number 60, covered by periodic patta number 10 of Sirangam ward, Dibrugarh town, Moja, which have been more specifically described in the schedule to the plaint. It was stated in the plaint that the plaintiff would have to pay a sum of rupees 1,50,000 to the defendant number one as a consideration for sale of the said land. And out of that, on 1/5/1998, the plaintiff paid rupees 9,800, semicolon. On 5/1/1999, paid a sum of rupees 25,000. On semicolon, on 9/2/99, the plaintiff paid another sum of rupees 10,000. And on 15/4/99, the plaintiff paid another sum of rupees 10,000. And the defendant, and it has been alleged that the defendant, number one, assured the plaintiff that he would soon take steps to execute the sale deed and will receive the balance consideration. First, it has been further alleged in the plaint that even after receipt of a total amount of rupees 54,800, the defendant neither took any steps for obtaining necessary sale permission and approval for the sale of the land, in spite of insistence by the plaintiff. First, but did not take any steps in the month of December 2005. On the other hand, on 22/12/2005, the defendant number two, with the wife of the defendant number one, in collusion with some other person, surreptitiously raised the torza wall around the said shop house in occupation of the plaintiff and completely blocked the front passage, for which the proceedings under section 133/145 of the CRPC was initiated. It is further stated that on the basis of the said, the plaintiff filed the suit seeking specific performance of the contract for sale of the plot of land described in the schedule below, in the schedule to the plaintiff, on payment of the balance amount of rupees 95,200 and for permanent injunction restraining the defendant number one from transferring the suit land. It is pertinent to mention that the suit was filed in the year 2006. On behalf of the defendants, a written statement cum counterclaim had been filed. In the written statement, it was specifically denied that the defendant number one had entered into any form of agreement with the plaintiff or have received any consideration. On the other hand, on that basis itself, the defendants have categorically stated that the question of specific performance of an non-existent agreement does not arise, for which the suit is required to be dismissed. It is further stated that since the month of June 2005, the plaintiff had not been paying the monthly rent in spite of repeated requests. Further to that, On the basis thereof, the counterclaim was filed seeking ejectment of the plaintiff from the suit premises. It is relevant to take note of that the plaintiff did not file any written statement to the counterclaim. And the suit proceeded. On behalf of the,
My lord, while adducing her, his evidence, my lord, he has categorically denied about the contestation made in the counter claim, my lord. That has been categorically denied, my lord. But that has not been considered by the trial court as well as by the appellate court also, my lord.
Mr. Das, that won't be proper, no? Because without pleading, there cannot be proof. Unless you have the defense, you cannot give any evidence. No? Can you give evidence? On behalf of the plea, on the basis of the pleadings, the learned trial court framed 7 issues, which being relevant are reproduced hereinunder. On behalf of the plaintiff, 3 witnesses were adduced and various documents were exhibited. On behalf of the defendant, 2 witnesses were adduced and various documents were also exhibited. It is relevant to take note of that the plaintiff, while adducing his evidence, did not adduce any receipts pertaining to payment of rent or depositing of any rent before the court. The learned trial court, while deciding the issue number 3 and 4, 3, 4, and 5, 3 and 4, came to a categorical finding on the basis of the evidence. That the plaintiff had failed to prove that there was an agreement for sale of the suit land. It was further observed that the plaintiff had also failed to prove the existence of any contract in accordance with law. And as such, the question of fulfilling the terms and conditions by the defendant number 1 does not arise at all. Further to that, the learned trial court, while deciding the issue number 3 and 4, also observed that there was nothing on record to show that the plaintiff ever asked the defendant number 1 since 1999 to execute the alleged sale deed in his favor, even after a period of 6 to 7 years. And accordingly, it was held that there was no lawful contract in between the plaintiff and the defendant number 1 to sell and purchase the suit land as alleged, and it also cannot be held that defendant number 1 failed to perform his duty. On the issue pertaining to the cause of action for a suit for counterclaim, it was held that there was a cause for the suit and the counterclaim. First, it was further held while deciding the issue number 655. Number 5. Issue number 6. That the plaintiff was a defaulter in paying the monthly rent since 2005. First, be it as it may, the learned trial court, while disposing of while passing the judgment and decree, declared that the defendants are entitled to recover and the plaintiff is liable to hand over the vacant possession of the suit premises to the defendant by removing his belongings therefrom within a period of 3 months from the date of the said judgment and decree. And further, it was held that the defendants were also entitled to receive the rents at the rate of 500 per month with effect from June 2005 till the date of the judgment and decree. And the plaintiff was also liable to clear the outstanding rents before the delivery of possession. Further to that, the learned trial court also held that the amount of rupees 54,800 paid by the plaintiff to the defendant number 1 would be adjusted on the rents payable to the landlords. Being aggrieved, an appeal was preferred by the plaintiff before the court of the district judge Dibrugarh, which was initially registered and numbered as title appeal number 10/2010 and later on re-registered as title appeal number 6/2017. The learned first appellate court while deciding the said appeal took into account the pleadings, the evidence so led by both the parties, the submissions so made by the learned counsels appearing on behalf of the parties, and then decided and took up the appeal for determination on the basis of the issues so framed by the learned trial court and by the judgment and decree dated, impugned judgment and decree dated 31/10/2019. Upheld the judgment and decree passed by the learned trial court dated 27/1/2010. And it is under such circumstances the present appeal has been preferred. In the backdrop of the above, let this court consider as to whether the two questions of law so submitted by the learned senior counsel appearing on behalf of the appellant can be formulated as substantial questions of law Full stop. The first question of law so submitted had been so proposed to be a substantial question of law is as to whether the judgment and decree passed by the learned courts below on the face of it were perverse, being not based on evidence on record, both oral and documentary. Full stop. The learned counsel, senior counsel appearing on behalf of the appellant had submitted that though there was no written statement filed against the counterclaim, but the defendant, but the plaintiff duly adduced evidence in support of that won't come here. As regards the counterclaim, that won't come here because that is the subject matter of the CRP. On the question of defaulter will be a question of subject. Now, what is this point? Why do you say it to be perverse?
As per which this province has laid down under order 41, rule 30 and 31.
We'll come to the order 41, rule 31. First come to why it is perverse.
Because not only the oral evidence, but the documentary evidence also, there is no any discussion in the appellate judgment, my lord.
What?
No discussion, my lord.
Very well discussed. What else is required to be discussed? Everything is there.
Yeah, in the appellate judgment, my lord, there is
What else is required? He has dealt with each and every aspect. Finally, see, Exhibit 19 are the receipts. There is no iota of thought that the defendant and the legal are the owners of the property. Exhibit 16 are 9 receipts. Then these are these.
No.
So he has sold this. Then Exhibit 3 is the no objection issued by so and so. Exhibit so and so. Everything has been discussed. What is there? Every exhibit has been dealt with. Finally, see. Exhibit 3 up to Exhibit 15 are municipal tax receipts.
Well.
The evidence of PWN further proceeds that the month of so and so, there was a negotiation between so and so. This is your oral evidence. Then what else is required? No.
Well.
Mr. N.C. Das, the learned counsel appearing on behalf of the appellant submits that the oral as well as the documentary evidence on record, insofar as the case of the plaintiff is concerned in the suit, was not discussed by the learned first appellate court. And as such, the judgment and decree so passed is perverse. Full stop. This court have duly taken note of the judgment passed by the learned trial court as well as the learned first appellate court, wherein both the courts below have duly taken into account the evidence on record and on the basis of that have arrived at the conclusion that there was no oral agreement. They had come to the conclusion that the plaintiff could not prove that there existed an oral agreement for sale of the suit land. Full stop. Under such circumstances, the question of framing a substantial question of law on the question on the basis of perversity does not arise. The second substantial question of law so proposed is as to whether the learned court below, first appellate court, had failed to decide the issues framed in the suit by discussing the evidence on record, both oral as well as the documentary, by formulating the points for determination, which violates the mandate of law as provided under Order 41, Rule 30 and 31 of the CPC. Full stop. The said substantial question of law so posed in the opinion of this court does not arise at all, taking into account that the learned trial first appellate court have duly taken into account the pleadings, the issues which were framed, the evidence so laid, the submissions so made, and decided each and every issues, taking into consideration the evidence on record. Consequently, there is no, consequently, the the question of law so proposed as a substantial question of law does not arise, cannot be formulated. Besides, it is a settled principle of law that Order 41 rule, the mandate of Order 41 Rule 31 has to be
This is my lord, I'm holding my lord. Year 2017, SCA page 5677, my lord.
Besides, the Supreme Court in the case of, in the case of Murugendra Indravadan Mehta and others versus Ahmedabad Municipal Corporation reported in 2024 INSC 401 categorically observed that if the first appellate court does not separately frame the points for determination arising in the first appeal, it would not prove fatal as long as the court deals with all the issues that actually arises for deliberation in the appeal. Full stop. Paragraph 30 and 31 of the said judgment being relevant is reproduced herein under. Full stop. In that view, in view of the above, it is therefore seen that there being no questions of law substantial, that as there is no substantial question of law that can be formulated in the instant appeal, the instant appeal cannot be proceeded with, for which the appeal stands dismissed. Other side appeared.
No, my lord.
However, in the facts of the case, this court is not imposing force.
I'd like to lord.
Well, in item number 4, I have received the instructions from the government today in the morning. मतलब the- ये देखो तो। I'll take the second page, Malad. In compliance with the Honorable Apex Court's order, various steps have been taken, Malad.
The data has been submitted.
In this particular case, it is submitted. Up to the Honorable Court order. There are other cases, Malad. In 3 cases, Malad, I have the information. In 1 case, I am awaiting the instruction, Malad. So for the stand of the government is concerned, this is the instruction. page number 13 is important. My lord. The instruction have been given from the headquarters to all the concerned SPs.
No, it is okay, but what they are doing,
My lord,
why this is not happening?
But the action taken report, in fact, page number 13, it indicates that the action taken report in this regard may please be furnished to the headquarters. But the action taken report also, there is a mechanism, my lord, I will file an affidavit, I propose to file an affidavit, my lord, in the matter,
Because what happens is,
my lord.
there has to be, I don't think this officers, the officer in charge and all these things may have been much aware or sensitive in regard to the directions which have been passed by the Supreme Court, which makes it mandatory upon them. Because the insurance company would not know till it is brought to the notice by the OC, by the investigating officer. So the moment he comes to know, yes, there is, if it is if the vehicle has fled away, it's a different thing.
That's it.
That can't help it. He may only register it. And then if he can't find it, then he has to give a report within 60 days. The period is also 60 days. This is mandatory. Now, in this case, when it is the vehicle is being seen, known, and there is now from the Parivahan thing only, you can, the moment you put that number, you immediately get which is the, whether he has insurance or not, whether there is anything out there, this is being there. Then there will be an offer being made to them. It will be informed. They will make an offer to the victims that look here, we are ready to pay this amount. And thereupon the things will move. Then you do the IR, then the DAR, first is the DAL, the first is the IR, PAR, IR, and then the DAR. Now, in the case of this stage 4, the DAR has been submitted.
Here, FAR, IAR and DAR.
DAR has been done.
Logic.
Now, remaining is the other. So the moment the DAR is submitted out here, it will obviously we will take it up as a claim, and the claimants will then they proceed with it. They can very well proceed. But what about the others? How are you implementing it? Because this matter requires an in-depth analysis on this.
But so for the instructions I received today, I have not seen that various communications have been issued to the concerned authorities to implement the honorable court order. And my lord, the order, it also indicates that they have sought for some reports of execution of the order. Lord, that thing, Lord, I need to have those inputs also to place it before the honorable court, because the implementation part, my lord, we have to look into.
No, have you issued in circulars?
Yes, my lord, they have, my lord, letters are being issued, page number 13, and in the bunch, in the instruction, my lord.
No, that is a thing which has been given by them.
Yes, sir.
That this is being given to these people, that look here, circulate. But why there is no direction that what you are required to do? Why the DGP or whoever it is, and the Assam Police Headquarters is not issuing instructions in terms with the judgment of the Supreme Court in Koharam, where there is specific directions being given in these two paragraphs, which I have noted at paragraph 59 to 61 of the said judgment.
Yes.
It categorically mentions what is the duty.
Lordship.
So why there are no directions being issued for implementation?
Well,
these matters, okay, I will take it from here and finish it off. But this is problem would keep on remaining till the problem will remain.
Yes, yes. My lord.
So therefore, unless you issue stringent directions that you are to comply with this,
a particular guideline,
and more particularly incorporate these three paragraphs in your guidelines, not the guidelines or in the form of, you don't issue guidelines in this. What do you say? You don't issue guidelines, because guidelines are not mandatory. But for compliance with it, you may have to issue a notification to that effect.
from the
saying
department.
this, and if failure to do that, it will incur some disciplinary action,
Action.
because these type of actions has to be given, but otherwise it will be a violation of the Supreme Court judgment.
That's it. True.
So what we do
Since lordship is in the
now,
custody.
as the DAR has been submitted in the Tezpur case, we allow for the DAR, on the basis of the DAR, the motor vehicle the MACT court to proceed with the claim proceedings on the basis of the DAR, and thereby allowing the claimants out there to proceed. Because on the basis of the DAR, it becomes a claim proceedings.
Sub-rule 21 says so, my lord.
So therefore, on the basis of the DAR, it will be a claim proceedings, and then the claimants will prove it. So for that, because I don't want to delay that proceedings, taking into account that if I delay that proceedings, a delay of a month or two is a question of imposition of interest, additional interest upon them. So let that proceed, but I keep this matter pending.
Yes, yes.
But only as an interim, I direct that in the meantime, taking into account the DAR has been filed in that, the motor vehicle, the court concerned, which is the court,
Tezpur.
it is given here. Why it is here, the DAR? Huh? The DAR has been filed here.
A copy, wrongly they have given here. Huh?
But that has to be completed in all
Deputy,
respects.
it's a submission of our DAR and so and so. Huh? He has given it here.
They have given a copy to me also. In fact,
I think this should go there.
this has to go there.
Huh?
This has to,
Simply, DAR has to be completed in all respects because there are various forms, my lord. Various forms, those forms have to be filled in up, my lord.
yes, it is already, it is done. Huh? In
No,
fact,
they have given various documents, rights of the victim,
yes,
interim, accident IR, DAR,
and Form 7 DAR, they have given.
then
There
these
are
are the three
prescribed
victim
forms, my lord.
documents which you have given. No, on the basis thereof, my only question is, once there is a DAR, the proceedings gets initiated. How the
Yes.
claimants prove is another aspect.
Yes,
No,
my lord.
That is another aspect, how they prove it.
But my submission is the rule says, my lord, that the DAR has to be complete in all respects because there are various forms. Those are issued by the police authorities to the concerned respective persons, my lord.
Hmm.
So those have to be filled in by the respective persons and those has to be returned to the police officers. Then only he can submit the DAR. For example, my lord, form 3 is there for the driver, form 4 is for the owner. Those have to
Offending
be filled
vehicle,
in up.
so and so, motorized two vehicle, private vehicle, driving Uttam Nandi, mobile number, so and so, permanent license, AS license number is given. Validity of the license, licensing authority, offending, the owner of the offending, who know so and so is being given. Insurance of the offending number, so and so, Bajaj Alliance given. Then vehicle was driven by others. Whether the driver was driving under the alcohol, no. Whether the driver was carrying mobile phone, no. Whether the driver personally involved in the motor accident, no. Whether the permit and fitness have been verified from the authority, no. Whether the owner reported the accident to the insurance company, no. In case the driver fled from the spot, driver is not fled from the PO. Then name of the deceased, no. Name of the injured given. Then Indian parent ration developed driving, causing of AR, motor vehicle is a so and so. On so and so at around Iman, the complainant so and so at about Iman. Iman struck the complaint from the front inside as a result of the Iman sustained injuries and complaints received to the faithful by each other. First accident report, PAR given. So those form 3 and 4, these are not being given. It's okay. Now, have they given it, this is being given to this court?
Well, they have sent I find that it is addressed to the Deputy Registrar of the Honorable Court and they have given it to me also. But they will
So,
submit
but-
it to the MSCT court, my lord. I'll instruct them if they have not.
No, I can ask the registry to forward this,
Lordship,
forward this
the
to
original?
the, which one, the Tezpur, huh?
This
It
is
will be
Tezpur.
before whom?
This
You
is
have a MSCT in Tezpur? So, on the basis of this, shall register a case and allow the claimants to participate in that, so that can proceed. Now, the question is, I'll keep the matter pending. Otherwise, I keep the matter pending on the basis, the matter is kept pending for the purpose of in further taking up with the authorities as to how they are to issue these notifications and all. These I will take it up.
My lord.
Because this is, I don't want to delay, because I can keep it delayed out here, but if I keep the delay of this matter out there, it is only a delay which is going to cause injury to you. We are only concerned with, in this case, is regard 166(3). Now, once the DAR is being filed, the problem is being solved. So for this matter,
The
we-
report, the report may be also sent to the insurance company as well, my lord.
you give a copy
My
to,
lord, I have the copy. I'll give my lord.
we'll give you a copy too.
And I will also instruct the officer concerned to send the original copy to both the court and the insurance company. I'll instruct them.
Pursuant to the order passed by this court on 13/5/2005, comma. It is seen that the superintendent of police Shonitpur Tezpur, by the communication to the Deputy Registrar Guwahati High Court, has submitted the first accident report bracket FAR, interim accident report bracket I, and the detailed accident report bracket DAR in respect to Tezpur Police Station case number 828/2022. Full stop. Mr. D. Nath, appearing on behalf of the Home and Political Department as well as the Transport Department of the Government of Assam, submitted that pursuant to the judgment of the Supreme Court in the case of Gohar Mohammed versus the Uttar Pradesh State Road Transport Corporation, certain steps have been taken for making the direction, for implementation of the directions contained therein, and sensitizing the police officials under the Assam Police, sensitizing the police officials of Assam in respect to the said directions. He submits that the Home and Political Department, as well as both the Home and Political Department as well as the Transport Department, are also emphasizing issuance of appropriate notifications so that the directions so passed by the Supreme Court in the case of Gohar Mohammed Supra is duly implemented in letter and in spirit. He therefore submitted that some more time may be given to the state government for issuance of these, some time may be given so that he can bring to the notice of this court the various notifications which both the departments are proposing to issue. And he would like to file an affidavit in that regard. he had also placed certain documents before this court, which are kept separately, which are collectively marked with the letter X and kept then X full stop. The registry is directed to maintain a separate file for these documents. Full stop. Next. It is relevant to take note of that in the present proceeding, that the present proceedings arises out of an application filed arises out a delay arising out Did you file a petition for
First of all, Lordship, without hearing us, Lordship, that mixed case was allowed. Subsequently, we raised the issue before the trial court.
arises out of condonation of a delay of how many days? 16 days in filing the claim proceedings, which was registered and numbered as MAC, case number 118/2022, bracket injury. That too without notice of the petitioners. It was the specific case of the petitioner, 1 or 2. Petitioner, 1, na? The petitioner, that in view of section 166(3) of the Motor Vehicles Act 1963, 1988, claim proceedings in respect to accidents occurring after 1/4/2022 cannot be initiated beyond the period of 6 months from the date of the accident. First, taking into account the directions so passed by the Supreme Court in the case of Gohar Mohammed, this court had passed certain directions from time to time in the present proceedings. As would be apparent from a perusal of the order dated, more apparent from the perusal of the detailed order dated 23/4/2025. Now, taking into account that the FAR, FAR, RIAR, and DAR have already been submitted in respect to Tezpur Police Station case number so and so. What this one, what? This
It was
PS case
820.
number. This one. This PS case number.
2822.
828/2022 have already been prepared. This court and have been submitted before this court. This court therefore directs the registry of this court to forthwith transmit the communication dated 22/5/2025 along with the FAR, R and the DAR in respect of Tezpur Police Station case number 828/2022 to the court of the learned
MSCD Tezpur.
MACT Tezpur. Member MACT Tezpur. Upon receipt of the said documents, more particularly the R and the DAR, the learned MACT, learned member MACT Tezpur shall proceed with, shall should we give a direction for re-registering?
Lordship, rule may be quoted, Lordship, for Lordship convenience.
I know that it is,
Rule
but
21
should
is
I
there.
give a re-registering or
Yes,
it
yes.
is already
That
registered?
that is detail in detail, Lordship.
Hmm.
Rule 21, Lordship. I can place it. Rule 1. Rule 21, Lordship. Case number 94, Rule 21.
That I understand. Now, should I re-register when you have already MAC case?
Lordship, that is there. Where the claimants have filed a separate claim petition, the DAR may be tagged along with the claim petition. And 22 is also there because charge sheet is, if charge sheet is filed, that is to be registered under section 166. And if not, it is to be registered under section 164.
Shall do the needful in terms with rule,
Sub-rule 21.
sub-rule.
Or because it is within the rule 150A of the motor vehicle rules.
No, that is not sub-rule. See rule 150, this is, shall act in terms with clause 21 of annexure 13 to the Central Motor Vehicles Fifth Amendment Rules 2022. For the sake of convenience, clause 21 is reproduced here in under. In that view of the matter, this court therefore directs the learned member Motor Accidents Claims Tribunal to treat the DAR as a claim petition under section 4 of section 166 of the Motor Vehicles Act 1988. The MAC case number
Lordship, 11822,
118
2022.
22 bracket injury be tagged along with the said DAR and on the basis thereof shall proceed with the disposal of the said claim proceedings in accordance with law.
Lordship, may I pray for mentioning this clause 22 also, because if the charge sheet is there along with the DAR report, Lordship,
Now here the charge sheet has been given.
if it is given, Lordship,
The
then.
charge sheet has been filed in this case.
Lordship,
No, if I remember earlier
Yes,
what
yes,
he
ye-
says,
yes,
the charge sheet has been given. Here, I have recorded it. No?
Yes.
Shall be treated as a claim proceeding and in case of the charge sheet, in case whether the charge before.
That column is blank.
Here, he has already said that the charge sheet has already been given. Somewhere I mentioned it when I got there. Earlier, he has produced the instructions.
Yes, my lord. Yes,
The charge sheet has been given.
yes, order dated 13/5/25, Lordship.
Huh?
Lordship may find it in order dated 13/5/25. Charge sheet has been filed.
13, 13/5.
In our instruction dated 8/5/25, Tezpur PS CS number 785 of 22, dated 29/9/2022.
So therefore, how the charge sheet will be filed? Brought on. Shall register the case under the. Should we direct the officer, he's the officer, is number 4. Should we direct him to place, give a copy of the charge sheet to the tribunal?
He is to give, Lordship.
No,
He is
he's
to furnish.
normally to give.
He is to
In
furnish.
fact, his DAR should include that.
Yes, yes.
What is the R? Let us see.
In the DAR column, my lord,
In fact, this interim, he says, on so and so, so and so, so and so, witness so and so, so and so, so and so. Details of the first incident not yet due to date of uploading file on the website of Delhi Police, insurance not delivered yet. Charge sheet given or not?
so the last page, 7 of 7.
Hmm.
Their report under section 173 CRPC, it is not marked. It is in blank.
Hmm?
Possible. The report, the DR report. my lord.
Hmm.
The page number, Lordship will find at bottom, right hand bottom, 7 of 7. At the top, my lord, serial number 17. Report under section 173 CRPC. That column here,
Of which one?
the DR, my lord.
DR, what is there? 17 is whether permit is there.
No, my lord, the Lordship is holding the DAR report, my lord. Dated
DAR,
DAR, page 7 of 7, last page.
7 of 6.
The report under section 173 CRPC, that column has been kept blank.
That is kept blank.
Blank.
Okay. This court further duly takes note of that in the order dated 13/5/2025, it has been duly recorded that the charge sheet in respect of Tezpur PS case number 828/2022 have been submitted on 29/9/2022 itself. Full stop. A copy of the said charge sheet is required to be a part of the DAR, which however is not here. So consequently, this court therefore directs the respondent number
Six.
Respondent number 6, that is the officer in charge of Tezpur Police Station, to forward a copy of the charge sheet in Tezpur PS case number 828/2022, dated 29/9/2022, dated no, or even here, to the learned member motor accidents claimant tribunal within 10 days from the date of the present order. I'll give it to you.
Alim, thank you.
The registry shall also ensure that the document that the PAR, R and the DAR, which are placed before this court pursuant to the order passed by this court on 13/5/2025, is also transmitted to the learned member motor accidents claims tribunal at the earliest, taking into account that the same is received by the learned member motor accidents tribunal within 15 days from today. Who is paying for the respondents? Anybody? No.
No, this case.
The stay order passed by this court on 27/3/2024 in respect to MAC case number, injury case number so and so, MAC case number 118/2022 injury stands vacated. And the petitioner, who is the insurance company, shall appear before the learned tribunal on 25th of June 2025. Full stop. The learned tribunal shall, before proceeding with the said claim proceedings, shall intimate the claimant about the order passed, taking into account that the instant order is being passed in absence of the claimant.
Lordship, one more prayer, Lordship. The DAR may be furnished to us on our appearance, and the clause 25 may be allowed to be carried out by the insurance company. Clause 25.
It is further observed that upon the appearance of the appellant, petitioner, who is the insurance company, a copy of the DAR be furnished to the petitioner insurance company, so that appropriate action can be, the obligations cast in Annexure 13 upon the insurance company can be carried out by the insurance company. Full stop. Next, that'll do. This court, however, taking into account that a larger issue is involved, keeps the present proceedings pending along with the remaining revision petitions, so that the implementation of the judgment of the Supreme Court in so that this court can pass appropriate orders to ensure the implementation of the judgment of the Supreme Court in the case of Gohar Mohammed Supra. List the matter again on 23rd, 18th of July, 22nd of July, 2025.
In
But
other
only-
cases, interim,
but,
Yeah, no, there's no interim in this case.
in other cases also.
Other cases, interim is there. So that beleke dibo. Taking into account the order passed in so and so in CRP IO number 111/2024. The interim order passed earlier shall continue. Zot interim order ase. Zot
but,
নাই, তাত vacate hoise, etu niriboi.
well, one clarification may be required. Well, the transport department has given me an instruction, and I have placed it before your lordship, well, that they said that the paragraph
Can't
number,
find it.
as per paragraph number 61, whenever the insurance company or the police authority seeks some verification of the records, the documents, insurance policy or something else, they will provide the document. They will provide the.
No. Therefore, what is required? No, I'm saying, therefore, you are required to issue notifications to the insurance also. And remember, you see, the power of the transport authority is so much as regards these insurance companies or even in respect to these manufacturers of cars are so much, which will be apparent from if you read the central motor vehicle rules in properly. You see, the transport authority has got enormous powers in this regard. So you issue a notification, that notification, just for example, the Home and Political will issue a notification in respect to the police officers. You have to issue a notification in regards to the transport also, this insurance also. They have to provide us all these details. So you have to do that.
And Malad, in respect of the other matters, Malad, the item number 7, Lord, sorry, item number 8. The SP Silchar has sent the similar FAR, IR and the DAR report.
It's given.
Yes, Malad, this is there. Malad. Lordship may pass a similar order, Malad, this will be given to the concerned MSCT, Malad, so that they can proceed. In item
And
number
their
8.
charge sheet has been given. Huh? Charge sheet given dated.
Item number 8.
এখনত এইটো দিব, এইটো A কৰিব এইটো, হা, এইটো বেলেগকে এটা, এইটো similar order দিব, খালি এইটো তাত নভৰাব. And another matter, any other matter?
Malad, item number 5 and 6, SP has informed us that FAR.
But
IR
in
and
this
DAR
case, have they included the DAR in the record? No. Where did they submit that?
No, Malad. In item number 4 is separate, Malad.
Ah.
Item number 4 is separate. And the item number 8, Malad, the lordship has directed on the other day that directed the concerned SPs to inform us whether they have submitted the FAR, R and DAR. In response to that, the SP Silchar has informed us that it has been submitted now.
In item number 8.
Item number 8.
And what was item number 4? 4 I passed the order, no?
4 lordship has passed the order.
Order to, then 5?
Item number 5.
Filed by, we are the respondent also.
Item
They
number
have filed.
6. Item number 5 and 6, same police case, there they have said it is not submitted. It is not submitted.
So 5 and 6,
5 and 6.
there's no interim order. 5 and 6 list the matter again on hetu koribo.
So there the police can submit it. It is not submitted, they can submit it.
Which one? 5 and 6?
Item 5 and 6.
No, therefore there will be, we'll see to it, no?
Hello.
The whether if you are submitted. 5 and 6, lekhi leho.
Not submitted.
Mr. Dina, the learned counsel appearing on behalf of the Home and Political Department as well as the Transport Department submits that as per his instructions, the FAR, R and DAR have not yet been submitted. Taking into account the above, list this matter on 22nd of July 2025, along with the CRP number 111/2024. Then 8 to 5 and 6 hoy gol. 4, done. 5 and 6 done. 7,
7, I have not received the instruction, Lord. I'm awaiting the instruction. In the meantime, I'll try. to-
7 list, 7 who has filed?
I have filed.
So it's 7 list this matter with CRP number 111/2024, comma, the interim order passed earlier shall continue till the next date, comma, the respondents shall, who's that? The Home and Political Department as well as the transport, the home of the government of, no, which will be the concerned superintendent? SPG?
Kokrajhar.
The SP Kokrajhar shall ensure that the R, FAR and DAR in respect to which case?
My lord,
Which case? Kalgosia?
No.
Kokrajhar Lordship, Kokrajhar Police Station case number 10/23.
10/23 is
Kokrajhar.
furnished to the learned member, Motor Accidents Claims Tribunal. MACT?
MSCD Kokrajhar.
Yeah. On or before the next date. And submit report before this court. Only report. Now this goes with 7. 8 interim order parcel shall continue till then.
8 already he has submitted. He will submit it to the SP has already given us report that FIR.
This
has been
is
submitted.
date.
This
This is 8.
8.
Okay, here they have not given it to me, not in the court, but you are going to submit it before the DAR.
Before,
Have you submitted? No.
possibly not. I'll instruct them to submit it. Not to
Okay.
observe it.
এইখানে এইটোত কৈ দিয়ক the Mr. Dina, the learned counsel appearing on behalf of the Home and Political Department of the Government of Assam submits that as per the instructions received from the Superintendent of Police Kachar, Silchar, dated 31/5/2025, comma, the FAR, R and R, it a full name did you, huh? First information, interim accident report and detailed accident in respect to Silchar PS case number 901/23 under section 279/338 of the Indian Penal Code have already been submitted before the learned court of the Motor Accidents Claims Tribunal, Silchar. Full stop. Taking into account, hey, তাৰপিছত এই আমি যোনখিনি ডাইৰেকশ্যন দিলো নহয় এটা কেছত আপোনাৰ এইখন দি দিব ক'লো নহয় দি দিয়াৰ পিছত যে ডাইৰেকশ্যন shall register it as so and so claim proceedings and act in terms of 21 কোড কৰিব দিছো ন সেই কোড কৰি and thereupon সেই 25 and 26 তাক যে এইখিনি ইনসুৰেন্সে পাব সেইখিনি লিখি দিব হা interim order yet vacated. Item number 8 vacated. That MAC case number kiman hobo silo.
The instruction, second page, the receipt copy of the MSCT is there. The receipt seal is there. 27/5/25 they have sent.
Have
Second.
been already received on 27/5/2025.
Lodge.
Have already been submitted before the learned member Motor Accident Tribunal on 27/5/2025. So we can dispose of number 8.
8 can be disposed.
8 we can dispose it of. I keep only triple
Item
one.
4 and 8 almost in the same situation. Item 4 and 8.
That's true. 4 is the lead matter. So as I am passing main orders there, so I don't need not say it. But 4, 8 need not be kept. It is not necessary
Good.
because it can be disposed of. 4 dispose of. Huh?
8 is disposed.
8. Item number 8 may be.
8 will be disposed. 4 remains.
4 remains.
4 remains because so that to ensure what is required to be done. Because the other matters will be, one on matter will be disposed of. But we require some things properly done. And do we need the other insurance companies here in this matter in 4? Taking into account that there is a duty under 149 upon the other insurance companies also.
They have filed lordship. They have also filed quite a few number of such cases.
That day, one case has been filed by Mr. A.J. Soikia. I fixed it on 13th of June, 13th or 23rd of June. I fixed it there. I thought it was, he said 13. Later on, I came to know 26. No, therefore he said 13. So I fixed it. Later on, I saw that this matter is fixed on 3rd. So that came only last Friday. So fixing it on 3rd makes no sense. So I then had it on 26th now. So that is another matter there. So there, that I'll connect it here. So that is one insurance company. But what about the others? Because taking into account this matter is being taken up for all others. Now we have the home and political department. Because you also have an issue as regards certain, if they have complied, you also can comply. You cannot comply with 149 unless you have information. Because there is also a corresponding duty of the insurance company also. So first they have to also come. So that is one necessary. So you can ask the other friends of yours who are there in the insurance panel to come, and if they have to make any submissions, they can very well make submissions out there at other insurance company. And if they need an impleading, we can implead them also, taking into account 111 is the lead matter, where I'm only taking up that issue. And the other matters will be obviously like one by one, it will be disposed of. Till this is not being done, because this we need to regulate it proper.
Yes.
And once it is then, there are lot and lots of things will be solved, I see.
That's listing that.
And the people will also, means one who wants to get, actually is required to get the compensation, he gets the compensation. And I'm really worried about the insurance interest. So therefore, in my
Yes, ma'am.
appeals,
is
when I admit the appeals in an insurance, I'm very, a bit, people may say that this judge is, such is very, he is not so easy on a statutory appeal. But the reason is that you have to also take care of, unless there is a very good ground, you cannot, because the interest is accumulating 9%, 8%, because the Supreme Court now has been giving 9%. And with these 9%, by the time it gets disposed of, it takes another 4 or 5 years. So it makes no sense. So that is why. Anyways, let's see. 111 will continue. Others for the time will continue. 8 we dispose it of.
All right.
Correct. 8 to dispose. Right? Don't worry.
Your lordship 9, item number 9, that is just very close. Item number 9, lordship.
9 is there.
Yes.
What is there?
Lordship, the previous, your lordship ordered it at 25/4/25, lordship, wherein directed me.
Why? What was wrong with you when everybody was here to come out here and put your voice out there? Why? Everybody was very well.
Your lordship.
When everybody leaves there. Now, what has happened in your case?
Your lordship, the previous order, your lordship has directed me to place the FIR to be lordship, yes.
FIR done.
Yes.
Dar, charge sheet,
Chip, only the Form 54 has submit me lordship before.
when was the FIR?
FIR lordship, which was filed on 13/4/2022, lordship.
And when did you file it?
And lordship, on 12th, lordship,
Huh?
one of the parents of another victim, lordship, it was filed, lordship. That is
Anyways.
13, lordship.
We can't help it now. Leave the matter on that day, 22nd of April, and be more proactive next time when the
Yes,
matter
sir.
is there, along with 111 observance. Be proactive. Why didn't you make a submission and with the past appropriate orders directing them to file?
Your lordship has ongoing process, lordship, so I cannot interrupt. it.
No, while coming there, everybody was here, na? I could see everybody's face out there. You were not there to be seen. Okay, let's come to number 10.
Your lordship.
Item 10 pertaining to Itanagar bench.
My lord, I am,
Oh, yes. What is the matter about?
Challenge.
my lord, I am appearing for the respondent side, my lord.
Yes, Mr. Panging, I can hear your voice, not you. Don't see you. Yes, what is the case
Yes.
about?
This revision has been prepared.
My lord, Mr. Deepangin, leading counsel put a respondent is out of station, my lord.
Okay, we'll see when the matter comes.
This revision has been prepared against a Kebang decision. Thereafter, an appeal was prepared, and against the appellate order, this revision has been prepared. What has happened, my lord? The petitioner number 1 and the petitioner number 2, who is the mother, the petitioner number 2 has expired, my lord.
Wait,
As per my instruction.
impugn order passed by whom?
Impugn order passed by both the orders of the Kebang decision as well as the, my lord, the order passed by the deputy commissioner as an appellate authority is under challenge for this revision application.
On what ground?
On the ground that, my lord, the Kebang decision, my lord, when it was passed, it superseded the earlier Kebang decision, my lord. Although there is no power for review, and thereafter the deputy commissioner has passed the appellate order, my lord. And when he passed, my lord, at that point in time, my lord, there was a notification to that effect that the judicial courts are, my lord, have come into place, my lord. And even knowing that the judicial courts have come into place, the deputy commissioner has exercised his power, my lord, notwithstanding the notification put up by the judicial department of the Arunachal Pradesh, stating that the issues will be now decided by the proper courts. And that at that point in time, thereafter, my lord, the my lord judgment is there, which was reported in 2022 SSC Online Guwahati 2174, wherein this honorable court was pleased to refer the issues before the deputy commissioner, because once the amendment came into being, my lord, then the deputy commissioners are divested of the powers to
After 1 year.
after 1 year. In this case, my lord, it was
But that came only in 2015.
yes,
That Civil Courts Act came only in 2015.
yes.
And then from that
No,
day,
21
1
million.
year was given to the deputy commissioners.
No, 21 the act came into being, Arunachal Pradesh Civil Code Act.
21.
Yes,
Okay, so 21 the came. Prior to that, this judgment was pronounced.
yes.
So what is wrong?
My lord, when this judgment was pronounced, my lord, what has happened afterwards, that is another aspect, my lord. What has happened before that, my lord, under the, my lord, Assam Frontier Administration of Justice Regulation, there is no power for review, my lord. Although review was done, and it superseded the earlier Kebang decision. Thereafter, my lord, the deputy commissioner, my lord, as an appellate authority, my lord, has passed an order, in spite of the fact that there is a notification to that effect that all these judicial courts have come into place. Even then, my lord,
No. First of all, tell me, can the judicial courts be given the power by way of a notification?
But the notification has come into effect.
No, notification. Let us see the notification.
Yes, ma'am. My lord will find at page 48, my lord.
Yes.
My lord will kindly see, my lord, Itanagar, 6th January 2014. May I read, my lord? Consequent upon the appointment of 5 Chief Judicial Magistrate come Civil Judge Senior Division and 5 Judicial Magistrate come Civil Judge Junior Division by the state government, and subsequent posting of the officers and vesting of power in them by the Honorable High Court by so and so. Notification number so and so dated 7/8/2013. So and so notification dated 12/8/2013. And notification dated 2/9/2013, so and so. The respectively, the governor of Arunachal Pradesh, in consultation with the Honorable High Court, is pleased to order the deputy commissioner, where the said judicial officers are posted, shall transfer all pending cases, both criminal and civil, to the courts of the said chief judicial magistrate, come civil judge senior division and judicial magistrate, come civil judge junior division, for trial and disposal. Henceforth, all cases, both criminal and civil, shall be instituted only in the court of chief judicial magistrate, come civil judge and and judicial cum magistrate civil judge senior division. The Governor of Arunachal Pradesh is further
So these
pleased.
notifications are where? Where are those notifications?
Not at the point at when the revision was filed, my lord, this notification was not enclosed. my lord.
No, these 2013 notifications
Yes, my lord.
are where? Does it say that it is in Alo, which was in West Siang?
Yes, my lord, there is.
There was a chief judicial magistrate.
Yes, there was a specific stand taken by the petitioner, my lord, that
Specific stand. You should have come up with that notification.
my lord, that notification was not filed
Then
along
you
with
cannot take a stand merely on the basis of thereof.
my lord, that notification was not enclosed with the revision application.
Whose revision petition is this?
Never mind.
Then burden lies upon whom? Now, just for example, I hold that this deputy commissioner did not have the power, but the fact remains as to whether there was a notification. Because you see the last paragraph. The governor of Arunachal is further pleased to order that wherever judicial officers are not possessed, the executive magistrate in the case, state vested with the power of judicial magistrate shall continue to exercise judicial powers only in respect to bail and remand cases. So therefore, the deputy commissioner retains the powers in the state of, in the district of West Siang, because Alo is the heading of the West Siang. Okay. Anyways, where is Mr. Banging? Anybody? Nobody. We do one thing. We have it on some other day.
Yes, ma'am.
When? Hey, are we to Kento? Kejini will need you advocate. Because Kejini has become a law minister long time back. What do you advocate? People will laugh at me. Mr. So-and-so appears on behalf of the petitioner, full stop. However, none has appeared on behalf of the respondent. Taking into account the issue involved, is the opinion of this court that without hearing the respondent, the issue involved, this court is of the opinion that a further chance may be granted to the respondent to appear on the next date. Accordingly, list this matter on an hour after vacation.
As my lord, please.
No, the question is this, why I'm saying that, taking into account that you may have to look into those
Yes, my lord.
notifications
On the next date, I will.
on 15th of July. On 15th of July at 2 p.m.
Oblige.
Item 22 fixed at 2 p.m.
Let's get a Cisco Leone. Wait, let me complete these orders first.
Item 11.
Item 10 to who? Item 10 is in CRP one. Okay.
May I please, Lordship,
Item 11, service upon respond number 1 not completed.
1-1.
I'm for
1-1 is not complete. Lordship, in due compliance to order dated 28/4/2025, we have taken the
No, no, no.
service.
File to be. Trustee,
Yes, sir.
you taken?
We have taken the steps on the respondents to Dusty, but in regards to 1-1, we have not been able to furnish the copy because she is not in the she is not available in the permanent address at Borpeta. She is reported to be residing in Guwahati in connection with her work. Also, we need some time to find her address in Guwahati. And the trial court record also has not been received yet.
You are appealing for 2, 3, 4.
I am appealing for respondent 2 and 3.
What about 4?
They are appealing separately. We are not appealing for separate.
Huh?
I am not appealing for respondent 4. I am appealing
4 service done,
Version done.
but you have filed Dusty.
Yes, sir.
And 1 and 2, 1-1 and 1-2 you could not serve.
Worship 1-2 is served.
You have filed the service of Dusty.
Yes, sir.
Affidavit of Dusty.
We have filed the affidavit.
It is seen that pursuant to the order passed by this court on 28/4/2025, the appellants have been able to serve upon the respondent number 1-1 Roman 2, 2, 3, and 4 by way of Dusty. And in that regard have also filed an affidavit of service on 26/5/2025. Mr. So-and-so appears on behalf of the respondent number 2 and 3.
2 and 3.
So taking into account the service upon the respondent numbers 1 Roman 2, 2, 3, and 4 are duly complete. However, as regards the respondent number 1 Roman 1, the service could not be effected as submitted by the learned counsel appearing on behalf of the appellant on the ground that the respondent number 1 Roman 1 was not,
She could not be found at the permanent address
could not be found in the permanent address.
at Borpeta.
Permanent address. Full stop. Taking into account the above, list this matter again on 22nd of July 2025, In the meantime, the liberty is given to effect service by way of Dusty upon the respondent number 1 Roman 1. Full stop. It is also seen from the office note that the LCR of title suit number 29/2009 have not yet been received. The registry shall ensure that the LCR of title suit number 29/2009 brought on record. Full stop. Further to that, the registry shall also give details as regards service by way of registered post upon the respondent numbers 1, 1.
So the record of title appeal is also not tagged with the.
It's okay, why it is there. Full stop. It is in your interest to get the matter disposed of early. You have got a decree, but you have not been able to get the delivery of possession. So if you delay, that is to your detriment. I hope you understand.
Yes, sir. Applies, sir.
Much of it.
Supplementary item 24.
Lordship, this item pretty fixed for order, your lordship. Anyway, on the last occasion, your lordship expressed the opinion that the matter will be disposed of.
Which one?
By hearing here today itself, your lordship. Anyway, your lordship, trial court's record has not been received. So for reminder has been issued, right?
Whether the learned first appellate court was justified in reversing the judgment and decree dated the month passed by the learned trial court in title suit number on a wrong application of time. Whether the decision and finding of the learned first appellate court is contrary to the pleadings and evidence of You are the appellant.
I'm a plaintiff appellant, your lord. The trial
You
court
lost the
dec-
case.
Trial court decreed the suit, first appellate court reversed, your lord. That's why it is a suit for specific performance of contract. So, your lordship, today I will press for the injunction matter, your lordship, at least status quo may be maintained in respect of the suit, your lord.
You have lost the case. What status quo
Before the
you,
first appellate court, your lordship. But first appellate court, your lordship, so far as judgment is concerned,
what injunction you want?
but at least the lordship, the status quo may be maintained, your lordship, as on today.
What status quo?
Not to transfer,
to
not
sell.
to alienate, not to,
Not to sell, that is only the status quo you can get, nothing more than that.
not to,
Alienate. Not further.
lordship.
My lord, in this case, my lord, after reversal, my lord, alternative prayer has been granted in favor of them. So I want to deposit the money also.
Oh, you have filed an IA?
Yes,
Where is the money?
1358. Otherwise, if
You deposit the money before the registry.
if order is passed, I will deposit.
That is done under order 24. You want to do it under 24. And as regards injunction,
Our specific stand is that we are not going to alienate because this property is required for our own purpose. So if we constructed.
no,
of our own-
construction, you go
Yeah.
ahead. You can do it.
Yeah.
There is only an injunction only in respect to
We will
not
not
to
create any third party right.
create third party.
Correct.
We will not create any.
You would not sell,
No, we will not sell.
sell or alienate.
Yes.
That's all.
But
Nothing more.
construction, we can.
You go ahead, construction, enjoy the property,
Not-
make trees, have mango trees by the time it is disposed of.
Fruit growing trees.
Eh?
Any fruit growing trees, your lordship,
Any
is necessary.
You would suggest more taking into account the weather, the jackfruit. Okay. I can heard Mr. S. Ali, the learned counsel appearing on behalf of the applicant, and Mr. S. Ghosh, the learned counsel appearing on behalf of the respondent. The instant application has been filed under Order 39, Rule 1 and 2, read with Section 151 for grant of a temporary injunction, thereby restraining the respondent, her men, agents, representatives, attorneys, etc., from selling and or encumbering the scheduled property and and from creating any third-party rights thereon till the disposal of the regular second appeal. Mr. S.K. Ghosh, the learned counsel appearing on behalf of the respondents,
Affidavit in op-
have filed their objection to the said application and has submitted that the respondents do not have any intention to alienate the suit property. Full stop. He further submitted that taking into account that there's a decree against the petitioners, applicants. There's a decree against the applicants.
Against us.
Should dismiss, your lordship.
So dismissed. So
By
there is
the
a
first
decree
applicant.
against them.
Alternative. Decree was.
Taking into account, he however submits that taking into account that the suit filed seeking specific performance have been dismissed, the respondent should not be restrained from enjoying the suit property. Full stop. Taking into account the above submissions and also taking into account the said submissions made by the learned counsel appearing on behalf of the parties, this court is of the opinion that as the regular second appeal has already been admitted by formulating certain three substantial questions of law comma. The property in dispute is required to be preserved. Considering the above, this court therefore directs the parties to maintain status quo insofar as title is concerned. Full stop. This court further makes it clear that the status quo order so passed as regards the title for maintaining the state as title, maintaining the order so passed herein as regards maintenance of status quo as regards title shall not, however, interfere in the enjoyment of the suit property which is presently in possession of the respondents. Full stop. With the above, the instant proceedings.
Your Lordship, may I say one thing, Your Lordship? As soon as the trial court's record is received by the Honorable Court, Your Lordship, the matter will be fixed for hearing, Your Lordship.
2024 matter.
Lordship. Simple matter, Your Lordship.
Simple matter is what? I don't do the simple matters. Whenever I admit an appeal,
Lordship.
I admit it with one substantial question of law. So it becomes more simpler. So here it is more tough. Now let is this. Heard Mr. S.K. Ghosh, the learned counsel, appearing on behalf on IA 1358, appearing on behalf of the applicant, and Mr. S. Ali, who appears on behalf of the respondent, opposite parties numbers 1 and 2, 1, 2, and 3. This is an application filed for depositing the decretal amount passed in judgment and decree dated 16/8/2024 by the learned additional district judge number 1 Kamrup Metro in title appeal number 14/2024. Full stop. The learned counsel appearing on behalf of the appellant, appearing on behalf of the applicant, submits that by the judgment and decree dated
Page 140 in main.
16/8/2024, passed in title appeal number 14/2024. The learned trial court, learned first appellate court had directed, had while interfering with the judgment and decree dated 30/4/2024, passed in title suit number 95/2016, held that the plaintiffs were entitled to get refund of the advance amount of rupees 11 lakhs along with interest at the rate of 9% per annum from the date of the judgment till payment is made, including return of another amount of rupees 2 lakhs paid on account of the defendant in the account of the defendant unilaterally on 5/6/2015. The learned counsel therefore submits that as there is an accruing interest at the rate of 9%, permission may be granted to the applicant to deposit the said amount before the registry and giving due liberty to the respondent, to the opposite parties who are the appellants in the accompanying appeal to seek release of the said amount if so advised. So, taking into account that there is a direction passed by the learned first appellate court to return the amount of rupees 11 lakhs with interest at the rate of 9%. Along with another 2 lakhs.
2 lakhs, that is actually it makes 13 lakhs, Your Lordship.
13 lakhs.
Along,
Because
It should be
before
13
the
lakhs,
trial
Your
court,
Lordship,
I
not
offered
11
the
lakhs.
money. Immediately after passing of the judgment, I offered the money before the trial court to deposit. But since they are not accepted, so interest part may not be there, madam.
So it should be
It's
13 lakhs. Your
along with the, along with the
2 lakhs,
amount of 2
2
lakhs,
lakhs,
comma,
13 lakhs, total 13 lakhs.
it is the opinion of this court that not permitting the petitioner, applicant to deposit the said amount as directed by the judgment and decree dated 16/8/2024 would cause difficulties on the part of the applicant. Accordingly, this court therefore grants liberty to the applicant to deposit the amount of rupees 13 lakhs before the registry of this court.
With same interest, your lord. With same interest.
Are you going to take release? Seek release? Yes.
No, no,
The
your
matter is over.
9% already given.
No,
your lord.
no. If you are asking for, you want to get it released, then the question is different.
9% from the date of judgment.
From the date of the judgment only. From 24
Yes.
till date. You deposit with the interest.
My lord,
From the date of the judgment, it is not much, 9% only, 11 lakhs, how much? 9%. It is not even a year now.
not, and I offered there also.
Understood, we'll consider later on. You deposit, let him take it. Matter is over. You should be happy. Along with interest
Interest calculation will
at
be
the rate of 9%
upon 11 lakhs.
as directed.
Upon 11 lakhs, 9%.
And accordingly, this court therefore disposes of the instant application, thereby granting liberty to the applicant to deposit the amount of rupees 11 lakhs along with interest at the rate of 9% from 16/8/2024, calculated from 16/8/2024 before the registry of this court. Full stop. In addition to that, the applicant shall also deposit, is also given the liberty to deposit 2 lakhs. Full stop. It is further observed that if the amount is duly deposited, it shall not be a bar on the part of the respondent, the opposite party who are the appellants in the accompanying second appeal to file application for release of the said amount. I disposed. RSA, what is happening?
My lord, trial court record.
Service complete.
Yes.
RSA Lekho, it is seen that the LCR of title suit number 95/2016 have not yet been received as would as would be apparent from the office note dated 17/5/2025. Full stop. The registry shall ensure that the records are duly received at the earliest and thereupon list the matter for usual hearing in the usual hearing on the usual course. Liberty given to both the parties to file appropriate application for early hearing.
Twenty-two fixed at 2 p.m.
Yes, what is the issue?
In this case, Lordship, our first appeal is against the preliminary decree, Lordship. That was with a
Whether the judgment and decree dated so and so is at all passed in accordance with Mohammedan law giving 50% to the only daughter plaintiff in presence of her four brothers, whereas per Mohammedan law, her specified share is 919. Correct in dismissing the first appeal of the defendants against preliminary point on the point of delay, whereas the delay was already condoned by the order dated in so and so. Whether the first committed error in interpretation. Actually, 2 and 3 is relevant. Why should we go into 1 if we allow 2 and 3?
one will be considered by first appellate court, Lordship.
Is
That
an
is
issue.
merit, Lordship.
Now the question here is that if I remember, as
Right.
this matter was taken up earlier verbally, both of you had submitted, more particularly you, have submitted that it was a preliminary decree. NSS section 97 would not apply. Section 97 only comes into play when it is a final decree.
If my appeal is against final decree, then I am precluded from filing appeal against preliminary decree.
Challenging the preliminary decree.
Lordship.
That is one. The second aspect is there was a delay.
Lordship.
The delay was not condoned.
Condone, Lordship.
Condoned, but then also that was overlooked.
Yes, Lordship.
And then it was dismissed on the ground of delay. Let us see the
No,
impugn.
Lordship, delay was condoned, then on the ground of section 97, my appeal was dismissed.
So then why did you frame the issue number 2, substantial issue number 2, question of law?
Both
I
one
have,
and
I
two.
have framed that whereas already the delay was condoned.
Understood. Then why did you frame that substantial question of law?
1 and 2 not maintainable. The
Huh?
one has been formulated based on a false statement. They have stated that the plaintiff allegedly claimed in presence of 4 brothers. That is not correct, my lord. My lord,
Challenge in this appeal is made to the judgment and decree dated demand passed in Iman whereby and whereunder the civil judge has decreed the plaintiff suit contest. Now let us see what is the judgment and decree dated 7/3/2009. Where
That
is
is-
7/3/2009?
7-3, Lordship, that is
7/3.
Yes.
In view of the above discussions and Iman and a plaintiff suit is decreed context of so and so and it is also that the plaintiff is entitled to get 50% from the suit plan which is specified. May decree be prepared. The judgment was against this,
yes, Lordship, the
the
preliminary
preliminary
decree.
decree.
Yes, Lord.
So this is being challenged here.
Challenge in the title appeal, Lordship.
Then how does 97 come into the picture?
my lord, 97 says that, my lord, when final decree is passed. Final
So-
decree is passed.
So is
Now,
that the reason why the court has done?
There is dispute
In
in the
this case,
past,
what happened, Lordship?
my lord, the
when-
titles, my lord, in the judgment, they cannot raise in any appeal. That section 97 say like that, my lord. So far my understanding.
No, understood. But the question is, the appeal which has been prepared is against the preliminary decree.
Preliminary decree.
It is against the preliminary decree, not against the final decree.
But the judgment of the appellate court,
Hmm.
that has been also decided, my lord, as an
Appeal-
judgment.
appeal
against-
Peruse the
against the-
citation
against the
submitted above, it appears the section
preliminary decree.
specifically provides that where any party is aggrieved by president does not appeal from the said decree, he is precluded from disputing its correctness is any appeal which may be preferred from the final decree. It is seen the preliminary decree was passed on so and so, which was required to be challenged within 1 month from the date of passing the judgment, that is on or before a month or before passing of the final decree. And the present appellants have miserably failed to do so and filed the present appeal after filing of the title execution case number so and so. In view of the above discussion, I hold that the judgment and decree passed by the learned court is wrong. How is it? First of all, you condone the delay. Does the appeal become not maintainable?
My lord, the provision says that dispute cannot be raised, is precluded in any appeal, my lord. The section 97 says like that, my lord, so far my understanding, my lord.
No,
He
my,
shall
my
be
appeal is
precluded from
against
disputing
preliminary.
its correctness in any appeal.
Madam, when I am in your favor,
Lordship.
you kindly don't say. I am therefore asking Mr. Sigdar. The moment I am in his favor, I will ask you.
My lord.
Tell me. As of now, I am in her favor. You tell me, how do you satisfy me that when the decree was only a preliminary decree, there was a delay, maybe a final decree,
Right.
whatever may be, but the challenge was to the preliminary decree. And
My
the
lord,
wording
my
out
lord,
here,
my lord, my submission is that
Hmm.
when the final decree is passed, my lord, is it not a situation, my lord, the final decree and preliminary decree is merged? Final decree has been passed, my lord. Is it not a situation that final decree and preliminary decree is merged and the court is to decide, cannot decide without saying anything about the final decree? Automatically, the court is coming to decide the issues raised in the, my lord, appeal. Everything, my lord, is
okay,
to
okay.
discuss,
Now
my lord.
tell me, Preliminary decree was passed on 7/3/1999. Okay,
My lord.
final decree was passed on
My lord, preliminary degree passed on 7/4/19, Fine.
7/3/99,
my lord.
isn't it? 7/3/99. 7/3/99. When was the final decree passed?
Final degree passed on 22/2/2020.
22 to
22.
22. Okay, final decree. Okay.
And they have filed appeal on 28/3/2022.
28/3/22. Against the preliminary decree.
Against the preliminary degree.
Against the preliminary decree. Appeal filed. Now, there was a delay.
There was delay.
Delay was condoned.
Well, my lord.
So what is the implication of the condonation of delay?
That has not been annexed in here.
No,
my
that
lord.
order is the next.
My lord. That condonation.
Page
Condoning the order.
69.
'69, my lord. Yes. Yes.
And that too when this very point was raised and rejected. Kindly see page 70,
My lord.
the second paragraph. The opposite party has submitted written objections stating that a preliminary decree in so-and-so was passed on Iman, which was required to be challenged within 1 month from the date of passing of the judgment, that is on or before Iman, and the present petitioner have miserably failed to do so. It is stated that on perusal of the report, dated so-and-so submitted by the learned circle officer, the learned court below, on so-and-so passed the final decree and the plaintiff has filed the Iman, and it is stated that after passing of the final decree, preliminary cannot be challenged after a long period of 365 days and prays for dismissal of the petition. After hearing the learned counsel for both, I found the grounds mentioned in the delay petition is good grounds and delay is condoned subject to payment of rupees 2,000. You did not challenge this. Now let us apply the principles of res judicata. The court, having rejected your submission, wouldn't the principles of constructive res judicata come into the picture? You have raised that point, and in verbatim, the same ground, the same court dismissed the appeal. Let us see how the verbatim language it is. Kindly come to again page 70 and the appellate court's judgment at page.
At page 73 onwards.
Where is the appellate court judgment?
My lord, at page 73 onwards.
73. 73, no, 73.
74.
No, exact words here, page 1684. Isn't it the exact repetition of the words? The same court, one hand, did not look into it, the other court.
My lord.
It is
My lord,
only the
the-
difference in the typewriting.
My lord, the court below has considered the condemnation on a different perspective. And the appeal has been dismissed, my lord, on a different perspective. My lord. The court has considered, I think my submission is that, my lord, when
When a party aggrieved by a preliminary decree passed after the commencement of this court does not appeal from such decree, he shall be precluded from disputing its correctness in any appeal which may be preferred from the final decree. So therefore, the language of section 97 is very clear that if you don't challenge the preliminary decree, you cannot challenge the final decree.
Yes, my lord.
Simple. Now, what has happened is, because preliminary decree already decides everything. as regards the shares. Now, in the final decree, if it is being passed, in a preliminary decree, what they will do? They will send it for, there will be a case of 50% has been awarded, there will be a partition by meets and bounds. That's the preliminary decree. So this further inquiry is required, and then therefore there is a case of preliminary decree. So once the preliminary decree is being passed to the commissioner here would be those persons, the collector. The collector grabs it and the collector gives it. Now, if she says she cannot thereupon challenge not on the question of how much they have got, but on the aspect which has been decreed out there in the preliminary decree, a challenge cannot be made by a challenge in the final decree. So what they are required to do, they have to challenge the preliminary decree.
Well, yes, in challenging the preliminary decree, my lord.
So therefore they have done the preliminary
They
decree.
have challenged the final degree also.
No, they cannot.
That has
Challenge.
been-
Therefore, they
yes.
say that they have challenged the preliminary decree. Now the question is the court should not have condoned. But if you say that because of there being a final decree, the preliminary decree cannot be challenged, show me some judgment in that regard where it says that if there is a preliminary decree being passed, a final decree being passed, then a challenge to the preliminary decree is barred. That can't be the law.
I may be given some time.
No, we finish it now. I've given you enough time. These matters have been, both of you have been asking me to finish it off, and this is a too small a point. And what are these judgments? Who has given this?
Lordship, one Rajasthan High Court full bench decision in Haridas case.
Huh?
I have cited.
What is this judgment?
In the-
Supreme Court. Challenge to the correctness in the final decree proceedings barred when no appeal was prepared by the defendant against the preliminary decree. However, still not inquired into by the trial court. Thus, even in absence of an appeal against the preliminary decree, since defendant have consistently raised fundamental averments in questions to warrant inquiry thereto by trial court, matter remitted to the trial court for consideration of the dispute on the basis of evidence. This is 142 exercise.
Lordship, in Haridas citation, Lordship, that is a
Huh?
full bench decision of Rajasthan High Court, Lordship.
Where? 97, order 18. Appeal from a final decree in absence of an appeal from a preliminary. In the suit for partition of a preliminary decree, and there was no appeal, therefore, the final passing of the final it would not be open to anyone to raise the comparison. The pending the suit for partition. What is this?
Lordship, in Harida's case, where question arose in paragraph 14, Lordship,
1-4.
whether an appeal from a preliminary decree would be incompetent if a final decree is made before the appeal from the preliminary decree is presented.
Presented has been considered by many high courts in the state and the reasons given. Two situations may arise in the case when appeal from an order of the month, just as the
Link on some government matter.
So this judgment I am bound. The judgment in the case of Taleb Ali versus Abdul Aziz. This is AIR 1929, Calcutta 689. Because in view of the order, Assam High Court's order of 1948, this judgment is binding on this court, being a full bench. Judgment is
We have three judgment, I have given, my lord. Our own High Court judgment is there,
full bench.
my lord.
Full bench.
My lord, it is, I've given, my lord, the AIR 2004 Guwahati 27. my lord. I've given, my lord.
No, is it full bench?
Agartala bench single judge.
Full bench.
Full bench judgment.
Full bench. High Court. Or High Court.
No, my lord. Full bench. Oh, no, my lord, it is single bench. But there are Supreme Court judgment also.
2, 3, 4, 5. It is the 5 judges bench of the Calcutta High Court, Taleb Ali. Let us see full bench. We consider it. This is a beautiful judgment. This is the Chief Justice ranking. What are your judgments? Supreme
My
Court
lord,
judgments?
my lord, AIR 1967, Supreme Court 1470, para 7, which is arising out of Rajasthan High Court.
Mr. This paragraph 7 is in respect to modification of a preliminary decree prior to the final decree being passed. It says, if the court which passed the preliminary decree can pass subsequent preliminary decrees, taking into account if there is any death in the family or something,
Right.
the shares go.
But not
devolved
after
and-
the final decree. But not, court has said it cannot be after final decree.
It cannot be after final decree.
Yes, sir.
But the fact is, final decree is passed is different. Once the final decree is passed here, but what happens, just for example, against the preliminary decree, you file an appeal. And after filing an appeal, that appeal is not executable? The decree is not executable?
Well, here decree was.
No, I'm asking you. A decree, preliminary decree is not executable. So you can't get a stay. Okay. Now everything goes on. Appeal is pending. I admit the appeal. Appeal is going on for years. In the meantime, final decree is passed because there is to stay. Then I find, no, this preliminary decree is wrong. And I say that it is bad.
Well.
Okay. When I say that it is bad, then what happens to the final decree? But the final decree is always subordinate to the preliminary decree.
Well, like, in the given case, the fact situation is something different, my lord.
I am
They have not-
giving you an
they have not
example.
filed the appeal against the preliminary decree before the final decree. They have, long after the final decree, they have passed. They have filed. the
No, but do
preliminary.
you have any judgments which says that there cannot be an appeal filed after the final decree is being passed? Appeal filed against the preliminary decree after a final decree is passed? Do you have any judgments in that?
My lord, I have given another judgment, my lord, year 1995, Supreme Court. Para 30 may, lordship may kindly have a look at, my lord. My understanding maybe.
30.
Para 30, my lord.
Can you see, on the contrary, you have the judgment?
No, I have no.
You have this. And then I see there is another copy here.
I have Only one copy?
No, no, I
Please give to the lordship.
don't worry, don't worry. Come to paragraph 30.
My,
On the contrary, have you got it in the middle?
my lord. On the contrary, yes, my lord.
If an appeal is filed against the preliminary decree without there being an appeal against the preliminary decree, and the preliminary decree becomes unassailable on account of 97, the notification on the heir would abate and the proceeding relating to the final decree without in any way touching, impairing, or affecting the parent. The reason to repeat is obvious. Once a preliminary decree is passed, the proceeding so far as declaration of rights and title in respect of are concerned comes to an end. Those rights are to be worked out by the final decree. In case, therefore, where a preliminary decree has been passed and only the proceedings relating to preparation of the are pending in the court, either at the original or at the appellate or revisional stage, it cannot be said that the proceedings relating to declaration or determination is within the meaning of pending. So therefore, if there is a decree, if there is a challenge to the decree, preliminary decree, it's okay. It can be passed. But without there being a challenge to the preliminary decree, you cannot question the final decree. So therefore, the judgment, therefore I say, the judgment in Talebali, which I was referring to, the Calcutta High Court, is directly on the point. And it's an interesting judgment. I think this is a judgment which needs to be incorporated more properly out here so that a person gets, anyways, so that is one. What about the second one? Second substantial question of, we have to impose cost upon you for framing so much of, for allowing the, asking the court to frame. Why are you raising issue number one?
Issue number one, lordship, I am the heirs of the sons,
Why
lordship,
are we taking issue number one? Substantial question number one.
50%, lordship.
Whether the judgment and preliminary decree dated
739.
so and so is at all passed in accordance with the Mohammedan law giving 50% share to the only daughter plaintiff in absence of his four brothers, whereas as per Mona, her share is only 1/9 only over the total property of late Sahar Ali.
My lord, that's a false pleading, my lord. In presence, the plaintiff has not claimed in presence of the, my lord, brothers. my lord. Fathers have already gone, other brothers have already gone, my lord, expired. He is the sole, my lord, legal heir of father and claiming. So
So
that
if,
pleading is
if,
not
if
correct.
I decide this, that this substantial question of law does not arise, number one, and goes against her, we need not decide 2 and 3. We put it at the nib.
Lordship can decide only on the basis of section 97, lordship.
Then why did you raise all these other things?
Those are the
So
points
once
on
you have
merit.
raised, I have to answer. How can I answer not? The moment I answer, if it goes against you, the other two becomes inconsequential.
Answer by remanding the matter to the first
Why
appellate court
should
to
I remand?
decide in merit, lordship, the first and substantial.
The
question.
second substantial question also not maintainable.
As
It's
because
not-
plaintiff in her plain stated
it
that
is the
at the time of her father's death,
So one, first substantial question, unnecessary fame. Second, unnecessary proposed. So that one 25,000, the second 25,000 makes it 50,000. Only third we allow it and pay you 50,000. What do you say? Let me come back and dictate the judgment. And in the meantime, a judgment will বুলি পঠিয়াম ইমেইলটো আমি heard Mr. R. Chaudhary, the learned counsel appearing on behalf of the appellant. Appellant or appellants?
Appellant.
Appellants. Appellants, many
Yes.
appellants. And
11
Mr. Sikdar appears on behalf of the respondent number one.
One, my lord.
Others are performer.
Performer.
None has appeared on behalf of the other respondents on board. This is an appeal filed under section 100 of the Code of Civil Procedure, challenging the judgment and decree dated 10/5/2024, passed by the learned District Judge Bongaigaon, entitled Appeal number 6/2022, whereby the appeal was dismissed, affirming the judgment and decree dated 7/3/2019, passed by the learned Civil Judge Bongaigaon, entitled Appeal, title suit bracket P number 31/2014. Full stop. It is seen from the records that by an order dated 30/8/2024, the learned coordinate bench of this court had admitted the instant appeal by formulating 3 substantial questions of law, which are reproduced hereunder. Full stop. Before deciding the 3 substantial questions of law, it is apposite herein to take note of that the learned First Appellate Court, learned court of the District Judge Bongaigaon, hereinafter referred to as the learned First Appellate Court, by the impugned judgment and or decree dated 10/5/2024, did not decide the appeal on any other aspects except on the question of maintainability of the appeal in view maintainability of the appeal in view of section 97 of the Code of Civil Procedure 1908. Full stop. The learned counsel appearing on behalf of the appellant submitted that inadvertently the first 2 substantial questions of law so formulated by this court was proposed though the learned First Appellate Court had only dismissed the suit appeal on the ground of maintainability. She therefore submitted that taking into account the learned First Appellate Court had dismissed the appeal on the ground of Section 97 of the Code of Civil Procedure. The third substantial question of law so formulated should be construed as the sole substantial question of law framed in the present proceedings. First, in addition to that, the learned counsel further submitted that as regards the first substantial question of law so formulated, a ground of objection have already been taken in the memo of appeal preferred before the learned First Appellate Court, which was, however, not taken into consideration, taking into account that the appeal was dismissed on the ground of being not maintainable. In the backdrop of the above submissions, therefore, this court would deal with the substantial questions of law so formulated by the learned coordinate bench of this court by its order dated 38/2024. This court further finds it relevant to take note of that in view of the submissions so made by the learned counsels appearing on behalf of the parties, the third substantial question of law would be taken up first for disposal, and depending upon the decision in the third substantial question of law, the other two substantial question of law so formulated would be decided. First, taking into account the above, this court finds it relevant to take note of certain brief facts which led to the filing of the instant appeal. First, you are the appellant.
Yes, Lord.
You are the plaintiff. Okay. You are the plaintiff. The respondent number one herein, for the sake of convenience, the parties herein are referred to in the same status as they stood before the learned trial court. First, next. The respondent number one as plaintiff had instituted the suit being title suit partition number 31/2024, seeking a declaration that the plaintiff is entitled to get 50% of the share of the suit land and the premises specifically described in the schedule to the plaintiff, semicolon, for a preliminary decree for partition of the suit property and to provide with 50% share to the plaintiff, semicolon, to issue a commission appointing the collector Bongaigaon to partition the 50% share of the plaintiff and for separate possession, semicolon, for a final decree embodying the commissioner's report, etc. The facts of the suit, the facts as pleaded in the suit, is that the father of the plaintiff and the father-in-law or grandfather of the defendant during his lifetime was the sole owner and exclusive possessor of a total plot of land measuring 10 bighas, 3 katha, 5 lechas, covered by Dang number 181 and 182 of periodic Patta number 75, situated at village Noldoba under Dangtol Revenue Circle of, what is this?
Vidyapur, Lordship.
Vidyapur.
Yes, Lordship.
Vidyapur? Huh?
Vidyapur Circle.
Vidyapur.
Sidli.
Then Revenue Circle Sidli.
Sidli.
Moza Sidli Part 1 in the district of Bongaigaon. Full stop. The father of the plaintiff expired long back in 1976, and his wife, Zamila Khatun, predeceased him, leaving behind the plaintiff as the sole daughter and 4 sons as the legal heirs. It was specifically stated that there was no partition done and the property stands as it was during the lifetime of the father of the plaintiff. It was further alleged that the 4 sons of the plaintiff, 4 brothers of the plaintiff, expired, leaving behind their legal heirs who have been impleaded as the defendants in the suit. The entire suit land at measuring 10 bighas 3 katha 5 lechas was under the possession of the legal heirs of late Sahar Ali. The defendant numbers 1 to 10, and only a small portion of the suit land the plaintiff was residing along with her other family members. The land measuring 10 bighas 3 katha 5 lechas is the subject matter of the suit property. It was further alleged that as per the Muslim law of inheritance, the plaintiff is entitled to 50% share of the suit land, being the only surviving lineal descendant of late Saheb Ali, Sheikh, but the defendant numbers 1 to 10 being the legal heirs of late Sahar Ali are not are not agreeable to give their share out to the plaintiff, and they are trying to grab the suit land by depriving the plaintiff from her legitimate 50% share in the suit land that accrued at the death of her father, and being the only surviving legal descendant. It is under such circumstances the suit was filed seeking the reliefs as above mentioned. The defendant numbers 1 to 10, who are the appellants herein, filed a written statement wherein denied to the wherein denied to the claim of the plaintiff that she is entitled to 50% of the share of the suit land. It was further mentioned that after that on 17/9/1971, Sohar Ali, since deceased, Jonu Ali, since deceased, Joynal Sheikh, since deceased, and Monu Sheikh, since deceased, executed a family settlement agreement wherein Jonu Ali, since deceased, Joynal Sheikh, since deceased, and Manu Sheikh, since deceased, relinquished their right, title, and interest from the suit land. Further, Jonu Ali, since deceased, Joynal Sheikh, since deceased, Monu Sheikh, since deceased, exchanged their share of the land with a plot of land at measuring 4 bighas 2 katha 5 lecha, which was the land of Sohar Ali, the predecessor in interest of the answering defendants. The predecessor in interest of the answering defendants was therefore the absolute owner and possessor of the said plot of land. The predecessor in interest of the answering defendants was absolute owner and possessor of the said plot of land measuring 4 bighas 2 katha 5 lechas, and after the said family settlement, Jonu Ali, since deceased, Joynal Sheikh, since deceased, and Monu Sheikh, since deceased, have been possessing the aforesaid plot of land measuring 4 bighas 2 katha 5 lechas. It was further stated that the plaintiff's share was 1/9.
Lordship, Our case is that lordship plaintiff will get only 1/9.
Did you say that in your written statement?
No, lordship, we have already said that already her share was given, lordship, after
It
partition.
was further stated that the plaintiff was given her share of land and she is therefore not entitled to any other area of the land. The defendant numbers 11 to 13 had also filed a written statement. Who supported the case of the plaintiff. The defendant number 16 filed a written statement supporting the case of the plaintiff. On the basis of the pleadings, the learned trial court framed as many as 7 issues, which are reproduced herein under page 38. On behalf of the plaintiff, 3 witnesses were examined and certain documents were 3 witnesses were examined and certain documents were exhibited. On behalf of the defendants, 2 witnesses were examined, but no documents were exhibited. The learned trial court, by a judgment and decree dated 7/3/2019, passed a preliminary decree. Full. It is relevant to take note of paragraph number 32 of the said judgment and decree. (32, 33) of the said judgment and decree, and the same is reproduced herein under. From the above quoted portion of the judgment and decree passed by the learned first trial court, that is the court of the civil judge Bongaigaon, it was decreed that the plaintiff is entitled to get 50% share from the suit land, which have been specifically described in the schedule to the plaintiff. The learned trial court further passed the preliminary decree thereby issuing a precept to the Deputy Commissioner Bongaigaon for partition of the suit land, which have been specifically described in the schedule of the plaintiff. It was also mentioned that after receipt of the report with regard to the partition of the suit land from the Deputy Commissioner Bongaigaon, the final decree would be prepared. The materials on record reveals that on the basis of the judgment and decree, on the basis of the preliminary decree so passed, precept was issued to the Deputy Commissioner Bongaigaon to carry out the partition. And accordingly, the Deputy Commissioner submitted the report, and on the basis thereof, the learned trial court passed the final decree on 22/9/2022. The record reveals that on 28/3/2022, the appellants herein, who were the defendant numbers 1 to 10, preferred an appeal challenging the judgment and decree dated, challenging the preliminary decree passed by virtue of the judgment and decree dated 7/3/2019, 2019, na?
2019.
2019. Along with an application for condonation of delay under Section 5, read with Order 41 Rule 3A of the Code. The application for condonation of delay was registered as Ms. case number 9/2022. The said application was allowed by an order dated 18/7/2023, thereby condoning the delay of 356 days. On the very date, the appeal was also admitted for hearing. Appeal being title appeal number 6/2022 was admitted for hearing. The learned First Appellate Court, that is the court of the District Judge Bongaigaon, by the impugned judgment and decree dated 10/5/2024, dismissed the appeal solely on the ground that in view of Section 97 of the Code of Civil Procedure 1908, for short the code, of the code, the appeal so filed challenging the preliminary decree was not maintainable on the ground that prior to filing of the appeal, the final decree was passed on 22/2/2022. It is under such circumstances the present appeal has been preferred. In the backdrop of the above, let this court now take note of the third substantial question of law so formulated by this court, by the learned court bench of this court, as to whether the learned First Appellate Court committed an error by misunderstanding and misinterpreting Section 97 of the Code. The judgment and decree dated 10/5/2024 is not sustainable in the eye of law. Ms. R. Chaudhary, the learned counsel appearing on behalf of the appellants, submitted that a perusal of Section 97 of the Code would show that if any party agreed by a preliminary decree passed after the commencement of the code does not appeal from such decree, he shall be precluded from disputing its correctness in any appeal which may be preferred from the final decree. The learned counsel therefore submitted that the law in this regard, that from the language so employed in Section 97 of the Code, there is a bar to challenge the findings in the preliminary decree. If there is no appeal preferred against the preliminary decree. The learned counsel therefore submitted that filing of a preliminary decree, filing an appeal against the preliminary decree, therefore submitted that the appeal having been preferred against the preliminary decree, so passed by the judgment and decree dated 7/3/2019, could not have been dismissed on the ground of the bar contained in section 97 of the code. The learned counsel referred to the judgments of the judgment of the Supreme Court in the case of Selvi versus Gopal Krishna Nair, dead through LRs, reported in 2018 7 SCC 319, as well as the full bench judgment of the Rajasthan High Court in the case of Haridas versus Bansidhar, reported in AIR 1962, Rajasthan 57. The learned counsel for the appellants further strenuously argued that the full bench of the Rajasthan High Court directly deals with this issue, and as such, and held and observed that an appeal preferred against a preliminary decree would be competent even if a final decree had been made before the appeal was presented. Per contra, Mr. A.R. Siddharth, the learned counsel, appearing on behalf of the appellant, respondents, submitted that the words used in section 97 of the code categorically mention that if there was no no challenge to the preliminary decree prior to filing or prior to making of the final decree, there can be no appeal preferred against the preliminary decree. In other words, it is therefore the learned counsel further submits that once the final decree is passed, a challenge to the preliminary decree is impermissible. In that regard, the learned counsel has referred to the judgment of the Supreme Court in the case of, what is the name of the judgment? 67. I gave you the name, na? I gave you a better copy of it.
My lord,
Name is not here.
here also, my lord, not clear.
Huh?
Here also not clear.
So and so versus Gopal Lal, reported in AIR 1967 SC 1470 and submitted and referred to paragraph number 7 of the said judgment. The learned counsel further referred to another judgment of the Supreme Court in the case of, here also, nothing can be seen. Mulchan, what is that? And others versus Deputy Director Consolidation and others reported in AIR 1995 SC 2493 and referred to paragraph number 30. In addition to that, the learned counsel further has referred to the judgment of the learned coordinate bench of this court in the case of, here also nothing can be seen. Kumar Bhattchaji versus Ratan Kumar Bhattchaji, reported in AIR 2004 Guwahati 27. এইকেইটা আমি মাৰি দিলে SCC অনলাইনত মাৰি দিলে আহি যাব। This court have duly given an anxious consideration to the respective submissions so made by the learned counsels appearing on behalf of the petitioners, and have also taken note of the judgments so referred to. Before proceeding with the adjudication on the issue, on the substantial question of law taken up for deliberation, it is relevant to take note of Section 97 of the Code, which is reproduced hereunder. From a perusal of the said judgment, from a perusal of Section 97, above quoted section, it would be seen that where any party aggrieved by a preliminary decree passed after the commencement of the court does not appeal from such decree, he shall be precluded from disputing its correctness in any appeal which may be preferred from the final decree. First, at this stage, this court finds it relevant to take note of Section 2(2) of the code, which defines the term decree to mean the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and may either be a preliminary or a final decree. It further stipulates that a preliminary decree a further perusal of the explanation to section 2.2 stipulates that a decree is preliminary where further proceedings have to be taken before the court can be completely disposed of it, and it would be final when such adjudication completely disposes of the suit. It also stipulates that that a court may pass a decree which is partly preliminary and partly final. Taking into account the definition contained in section 2.2, and read with section 96 of the code, it is seen that an appeal shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decision of such court. Therefore, in terms with section 96, an appeal can be preferred against the preliminary decree or also against the final decree. Section 97. It is further relevant to take note of that the preliminary decree in a suit for partition further relevant to take note of that a preliminary decree under the code determines various questions such as liability to account, existence of mortgage, shares in joint property, etc. On the basis of such adjudication being carried out in respect to the preliminary decree by the court, the final decree is prepared. Therefore, in a suit for partition or in a suit for of mortgage or a mortgage suit, the final decree the function of the final decree is merely to restate and apply with precision what the preliminary decree has ordained. It is also the opinion of the court that the final decree so passed in a suit for partition where a preliminary decree has been passed becomes dependent on the preliminary decree. And if the preliminary decree is interfered with, the final decree is superseded. In the backdrop of the above, if the provisions of section 97 is being taken note of, it would be seen that if the preliminary decree is not assailed, the final decree so prepared on the basis of the preliminary decree, the findings made in the preliminary decree cannot be assailed. Full stop. However, section 97 in the opinion of this court, does not bar a challenge to the preliminary decree. And what it does is only to bar the challenge to the contents of the preliminary, the findings and contents of the preliminary decree. Only bars disputing the correctness of the preliminary decree. If no appeal is preferred against the preliminary decree and an appeal is preferred against the final decree. Full stop. The observations so made herein above by this court is supported by the judgment of the full bench of the Calcutta High Court in the case of Taleb Ali versus Abdul Aziz, reported in AIR 1929. I gave this citation now. Where is it?
AIR 1929, Calcutta 689.
In 29, Calcutta. Six, eight, nine. Wherein the full bench of the Calcutta High Court had categorically answered that an appeal from a preliminary decree is not incompetent if a final decree is made before the appeal is presented. The relevant portion of the said judgment is reproduced herein under. এই চাব হা মই এইখিনি ঠিক মাৰ্ক কৰি দিছো হা 1039 হা it is relevant to take note of that taking into account the Assam High Court order 1948 লিখলি the Assam High Court order 1948 more particularly clause 12.4 1948, comma. The judgment of the full bench of the Calcutta High Court would be a binding passed in the year 1929. Would be a binding precedent upon this court. This court also finds it relevant to take note of another judgment of the full bench of the Rajasthan High Court in the case of Haridas versus Bansidhar, Bansidhar, reported in AIR 1962, Rajasthan 57.
Banshidhar.
Wherein the similar opinion have also been expressed as regards filing of an appeal, as regards the maintainability of the appeal against a preliminary decree after the final decree has been passed. Considering the above, this court, therefore, is of the opinion that the third substantial question of law is duly involved in the instant appeal. First. Now let this court take note of the second substantial question of law. First. In the opinion of this court, the second substantial question of law which relates to whether the learned first appellate court was correct in dismissing the first appeal against the preliminary decree on the point of delay, whereas the delay was already condoned by the order dated 18/7/2022 in Miss Case number 9/2022. In the opinion of this court, is not at all involved in the instant appeal, taking into account that the first appellate court, learned first appellate court, dismissed the appeal only on the ground of section 97 of the code.
May I point out one thing? It is written 2-3 lines on delay part, Lordship. Also, it is seen that the preliminary decree in so and so, which was required to be challenged within 1 month from the date of passing of
That
the.
that is his submission.
No, Lordship, that
And
is the
this is exactly what has been mentioned out there.
page 84, finding of the first appellate
But
court.
that
is
has no relevance. After condoning the delay, this has no relevance at all. The
For that
question,
only I have
he had given a justification taking into account that after 1 year, he has filed an appeal. And as such, can that appeal be maintainable? That is his finding. This has no relevance out there.
That is the final finding.
According,
paragraph
not
60.
involved. In respect to the first substantial question of law, comma, it has been submitted at the bar that the ground of objection, that in the ground of objection taken in the memo of appeal before the learned first appellate court, the issue as regards the respective shares of the parties in terms with the Mohammedan law have been duly taken. This court further takes note of that the appeal was dismissed by the learned first appellate court on the ground on the ground of maintainability and not on merits. And consequently, this court therefore is of the opinion that this is a fit case for setting aside the impugned judgment and decree dated 10/5/2024, passed entitled Appeal number 6/2022, and remand the appeal under Order 41 Rule 23A to the court of the learned first appellate court, to the learned court of the district judge, Bongaigaon, for deciding the appeal on merits. In that view of the matter, the instant appeal stands allowed with the following observations and directions. The judgment and decree dated 10/5/2024, passed entitled Appeal number 06/2022, pending by the learned court of the district judge Bongaigaon, is set aside and quashed. Number 2, this court remands the appeal being titled, restores the appeal being titled Appeal number 6/2022 to the file of the learned district judge Bongaigaon, and remands the appeal, and upon restoring, remands the appeal to the learned first appellate court, that is the learned court of the district judge Bongaigaon, for deciding the appeal on merits. Number 3, taking into account that the substantial question of law number 1 so formulated have not been decided herein. This court, taking into account that the remand have been made, this court have remanded the appeal back to the learned first appellate court for decision afresh on merits, comma. This court have not decided on the question of entitlement as have been decided by the preliminary decree. made by the judgment and decree dated 7/3/2019. And the learned party, the parties before this court and the parties in the appeal, entitled appeal number 6/2022 shall be at liberty to urge their grounds, would be at liberty to make necessary submissions in respect to their entitlement before the learned First Appellate Court. This court further, taking into account both the parties are represented before this court, and there is an order of remand being passed, by exercising the powers under Order 41, Rule 26 of the Code, directs the parties to appear before the learned First Appellate Court, that is the court of the District Judge Bongaigaon, thereby fixing 21st of July 2025 as the date for hearing before the learned First Appellate Court. Anything more? LCR be returned for tweets and in necessary special messenger will likhi dibo, huh?
One IA is there, Lordship. One IA is there, Lordship. that has
For
been-
what?
For stay of the judgment, Lordship. That is there, within it, notice was issued. That
Now
is
I have given
disposed
it.
of.
You have a stay there.
No, next date is on 16/6. Stay of the appellate court judgment. Yes, Lordship, on last occasion, your Lordship has done.
No. First Appellate Court only dismissed it.
Yes,
Now
Lordship.
the question is, you have to ask for stay of the final decree.
Yes,
How do you ask for? You have to file an application there, na?
yes, Lordship.
We'll do one thing. I can the option
2441, Lordship.
2441.
On last occasion, your Lordship already stayed the judgment of the First Appellate Court.
That Arvata likhi di. Taking into account that the appeal has been restored, this court further stays the operation of the judgment and decree. No, not the judgment and decree. Stay the
Appellate Court judgment.
no, the trial court's judgment.
Lordship, on.
First Appellate Court is a dismissal, madam. We have to stay the judgment.
Yes, Lordship, by 6/5, your Lordship has already.
States the
said-
judgment and decree dated 22/2/2022, which is the final decree passed by the learned trial court. That is the court of the so-and-so, entitled suit number so-and-so, till the next date, till, what is the date?
16/6, Lordship.
I fixed 16?
No,
No.
Lordship has fixed on 21/7.
21/7/2025, which is the next date fixed before the learned First Appellate Court. The appellant's hearing shall be at liberty to file appropriate application before the learned First Appellate Court for further extension of the stay so granted herein. Take a look.
Item 23.
What is this?
Control supervisor. Ex parte decree was first confirmed by the appellate court.
Yes, we are arguing. What is there? Others may go. I'll deliver the judgment. Any urgency, anybody's? Mr. Roy Chaudhary? Any urgency?
I am in the wrong, I will not place, I am in the wrong court in the one case. I am a tenant, I will not place any urgency.
Mr. Sharma, anything?
Item number 12. It is a 2010 second April.
Okay.
It may be listed.
What is this item?
Yeah,
24?
item 12. Our item
Yours is item 10.
12.
You want to do it, Mr. Sharma?
Yes.
Which you can do it. They can make 2010 second appeal will have a precedence. You want to do it?
We are ready.
You are for the respondent?
I am for the respondent.
Who is for the appellant?
He is not present, my lord. On earlier occasion, so the appeal was dismissed for default.
Okay. Call item 10.
12.
12.
Item 12.
Why is this matter called up? Precedence is being given. Huh? Okay, okay. Item number 23. 23. Okay. This is for admission, it should come.
Yes, Lord.
Item number 23 will come up for admission. When do you want it?
On 19/5, it was, on 19/5, it was listed before your lordship, and your lordship has fixed it today. May it come up day after tomorrow?
No, day after.
No.
Day after tomorrow.
On 10th, then next Tuesday.
No, this is landlord tenant, no?
Six-party decree was passed, they did not contested the suit.
Lordship, we were contesting the suit, Lordship. Lordship, we were
After signing
contesting,
of the WS, they did not appear, and
Lordship, there are
that is
reasons.
why your lordship has fixed it today for this final disposal. Because no evidence has been laid, nothing, no
Understood. Everybody
cross-examination
has
has been done.
urgency.
So,
Okay. Where is your senior? Dismissing this type of cases in your presence of your senior is more happiness than
he was passing
dismissing in
2015,
presence
my
of the
lord.
junior advocate. Huh?
If we fix the next date, I will inform him, Lordship.
Ask him.
Lordship.
Ask him and come up before this court with a prayer that 6 months you are going to vacate. Nothing more than that. We have it next Tuesday. No, these are not matters of Tuesday. We'll finish it on any other day. This is on, today is what?
Third.
Okay. We'll have it on 11th for admission. So and so, 11th for admission. Admission will finish.
Pledge, Lordship.
It's simple. Get your instruction, 6 months to vacate. Nothing more than that. What is this? Item number 12. Below that the suit land is covered by dark number 946 is perverse. So we dismiss for default.
My lord?
You have to dismiss for default only.
Yes.
There's no way out. I can't decide on merits. So stop. None has appeared on behalf of the appellant on call. Mr. A.C. Sharma, the learned senior counsel, assisted by Mr. G. Bharadwaj, appears on behalf of the respondent number 1.
Yes.
So stop. Taking into account that this is an appeal from the year 2010, and the appellant have not been represented, comma, this court dismisses the instant appeal for default. The LCR be returned within 90 days from the date of the instant order. Everybody has gone. Oh, I gotta finish up the other matter. Mr. Sharma, you have a look at the judgment of Taleb Ali. One of the very fine judgments of Chief Justice Rankin. So 5 judges on how he says about what is a preliminary decree and final decree. Very beautifully given.
Yes, yes.
Yes, just ask him to take a copy of it. a very beautiful judgment. And it's normally you don't find that. It's not reported in AIA. It is reported. I don't know. It's reported in 1929. Many may not have it, but otherwise it's a CWN. It's a 5 judges. Very nicely written.